Item number 4, delivery order.
For reasons mentioned in the order, the petitioners are allowed to go on bail of rupees 1 lakh each with 2 sureties of like amount, subject to certain conditions mentioned in the order.
Pablo.
Item number 5,
Let it be taken up as the last item because both sides are on them.
Okay.
Oblige me.
item 3. Item number 3,
After some time.
item 6,
May I please, Lordship? Well, this is the subsequent bail application. Earlier, your Lordship has rejected this application, that is, your Lordship will find at page 12. The earlier order of this honorable court.
Page
12. Well, not relevant is page 13, third paragraph. Lordship.
Yes, sir. Yes, page 13.
Page 13, third paragraph. On the other hand, Lordship.
Yes.
On the other hand, the learned additional public prosecutor for the state of Assam has submitted that there are sufficient incriminating materials against the present petitioner in the case diary. It is also submitted that though the victim has refused for her medical examination, however, in her statement recorded under section 164 CRPC, she has categorically implicated the present petitioner and thus additional public prosecutor for the state of Assam has opposed the prayer of the present petitioner. Well, this has categorically supported the declaration that has been made by the victim herself. That is, your Lordship, page 15. This is the ground for subsequent bail application. Page 16, paragraph 4. Start from 15. Due to the ill advice of some antisocial element, village, I had lost the aforesaid case. In fact, no such incident was happened, as written in the affair. As such, I did not want it to have a medical examination. However, after registering the case, I approached before the OC Bleshipara with a request to stop further investigation of the case, as I am not interested to proceed further with the case. But the IO did not act upon my assertion as the case is registered under section 376(1) IPC. Well, the victim has already appeared, or she notice was issued.
Victim has appeared.
Well,
You are appearing for victim. You don't have any objection.
No one. Because below the amicably settled the issues, Malab.
Yes, Mr. Butcher. Let him appear. This is an anticipation.
well,
On earlier occasion, the victim did not appear.
no,
Let's say we have received the city.
What is there in the case diary?
This is last updated up to let's say
What is the statement of the victim?
5/10/2023. Both the 161 and 164 statement of the victim available in the city, and also the along with the witness, 3 numbers of witness are examined. So, Lordship may kindly peruse the city. I have flagged the relevant portion.
It is there are incriminating material.
Lordship, here the thing is that she refused for the medical. So that is also reflected
Okay.
for the medical examination. But 164 statement is there and it is 376(1).
She has implicated.
Lordship, she refused for the medical.
No, but in 164 statement.
Yes, clearly states in 164, even in 161.
Now, how, this is your affidavit.
My lord.
That is a declaration,
Declaration of.
That is a
form of
declaration.
affidavit, my lord.
That is given by you.
My lord.
and it is not a compoundable offense, Lord.
That is
Okay.
there, but so
Okay,
far
but then his custodial detention may not be
that
necessary.
is,
My lord.
Heard Mr. M. Khan, learned counsel for the petitioner, also heard Mr. K. Bosho, learned additional public prosecutor, as well as Mr.
K.R. Patgiri, my lord.
K. R. Padgiri, appearing for the
50 means.
victim informant. Stop. This application under section 438 of the Code of Criminal Procedure, 1973, has been filed for the second time by the petitioner Ruhul Amin alias Rahul Hussain alias Rahul, who is apprehending his arrest in connection with Vilasipara PS number 213/2023 under section 448/376/506 of the Indian Penal Code. It is pertinent to mention herein that on an earlier occasion when the petitioner approached this court by preferring an anticipatory bail application which was registered as AB 2141/2023, his prayer was rejected by order dated 26/7/2023, wherein on the ground that there was sufficient incriminating material against the present petitioner in the case diary. The gist of accusation in this case is that the victim / informant lodged an FIR on, where is the FIR?
28, my lord, affair is page 9. So the A7. A7 translated part. On Bhanukular,
FIR on 16.
my lord, affair lost on 31/5/23.
On 31/5/2023, comma, inter alia alleging that the present petitioner, comma, on 28/5/2023 at about 11:30 PM committed rape on the victim and also threatened to kill her. So, learned counsel for the petitioner has submitted that the petitioner is an adult woman aged about 30 years, and she has falsely implicated the present petitioner. It is further submitted that in this regard, the petitioner has sworn a declaration before the notary on 20/11/2023, whereby she has stated that she lodged the FIR against the present petitioner due to some ill advice given to her by some of her co-villagers. She has also stated that in fact no such incident as alleged in the FIR had occurred, and therefore she had refused to undergo medical examination. Stop. On perusal, learned counsel for the victim, Mr. K. Padgiri.
K.R. Patgiri.
K. R. Padgiri, learned counsel for the victim / informant, has also admitted that the petitioner has in fact sworn in the affidavit, in fact sworn in the undertaking, sworn the declaration which has been annexed along with the bail application as Annexure 3, and the victim / petitioner does not have any objections if the present petitioner, no, the victim slash informant does not have any objection if the present petitioner is allowed to go on anticipatory bail. Stop. I have considered the submissions made by learned counsel for the parties, for both the parties, as well as peruse the materials on record, including the case diary of Bilasi Para PS case number 2213/2023. Though in her statement made under section 164 as well as 161 of the Code of Criminal Procedure, the informant has implicated the present petitioner. However, in view of subsequent development, that is, in view of the undertaking given by the victim, wherein she has stated that nothing as alleged in the FIR has happened, and therefore she had refused to undergo medical examination test, becomes relevant for consideration of the instant bail application. Considering the declaration made by the victim as well as submissions made by learned counsel for the victim that the victim does not have any objection if the present petitioner is allowed to go on bail, this court is of considered opinion that the facts and circumstances of this case are such, facts and circumstances of this case does not justify custodial detention of the present petitioner for sake of completion of the investigation in Bilasi Para PS case number 213/2023. Hence, stop. In view of above, the petitioner Ruhul Amin alias Rahul Hussain alias Rahul is hereby directed to appear before the investigating officer of Bilasi Para PS case number 213/2023 within a period of 10 days from the date of this order before the investigating officer and cooperate in investigation. Stop. If he does within the stipulated period, if he does so within the stipulated period of time, in the event of his arrest in connection with Bilasi Para PS case number 213/2023, the above named petitioner shall be allowed to go on bail of rupees 30,000 with one surety of like amount, subject to following conditions. Subject to the satisfaction of the arresting authority with following conditions, number 1 and number 2. With above observation, this bail application is hereby disposed of.
Last
Bail request.
Item number 2.
May I please, Your Worship? Lordship, kindly may adjourn the case today, Your Worship.
Lordship, in this matter, city not received.
Heard Mr. K. Thakur, learned counsel for the petitioner. Also heard Mr. K. Bosho.
Lordship,
Is it 2K or single K?
only one case, Lordship.
Heard Mr. K. Bosho, learned additional public prosecutor, who prays for another date for
Lord.
producing the case diary. The prayer is allowed. Let this matter be listed after on
81. Lordship, it is in 29th, Lordship.
29th January
Highly appreciate.
for case diary.
Item number 1. Item 1.
My colleague is just visited in the court campus. He is just coming upstairs.
Okay, let him come.
Within 5 minutes, he will.
You can brief me regarding the facts. Who is appearing for the other side?
CBI,
CBI counsel is there.
CBI counsel,
You are NCB. CBI counsel,
Manas Alai was there.
CBI counsel would be required.
Yes. I'll just ring him.
Let him come.
Yes.
Mr. Mahajan, you are ready? Okay.
Similar order will also be
Co-accused is released.
released by a lordship.
You have the order.
Lordship, I placed on last occasion, stay in the file.
NCB, Mr. Kyle is there.
Yes, Lordship, he is on legs in court number 15.
Okay. What to do?
Similar order lordship is passed.
No, Lordship.
No, we have to hear them. Because
Lordship is sitting at.
okay, we'll sit after half an hour
Okay, Lordship.
at 12:30.
Okay, Lordship.
Let my.
Mr. Bashir, you don't have any matter, no? Your matters are over. At 12:30, I'll try my luck. Whether Mr. Kyle is available.
Yeah, my lord, with all respect, my lord. The accused before your lordships, my lord, he is facing trial. And he is there for 3 years, 10 months and 27 days, my lord. And my lord, to be very precise, my lord, one co-accused, he has been granted the privilege of bail, my lord. But apart from parity, my lord, the merit also is same, my lord. My lord, all these authorities of the apex court latest, my lord, primarily is based on Article 21. No person shall be deprived of his life and liberty except according to procedure established by law. The intention of the legislature so far as enacting, my lord, the NDPS Act was very clear, my lord, transparent, and apparently to the effect that this, my lord, offences, my lord, with all respect, whereby society is demolished, the demeaned, my lord, should not get the privilege of bail very easily, my lord. Hence, my lord, 37 and whatever be it, my lord, those were created, enacted, and incorporated. Now, my lord, these authorities, latest ones, my lord, only because of the reason, my lord, first of all, Article 21 has to prevail, my lord. Now, my lord, the accused who has been granted the privilege of bail, and it's a very detailed order, wherein, my lord, everything has been discussed, with all respect, my lord. I same on the same footing, my lord. There are several authorities also, my lord.
You
that
are from the same FIR.
Same affair, same facts, same vehicle, 5 persons, one has been granted. My lord, there are some authority that in, my lord, grant of bail, my lord, there are different authorities, my lord. Law is developing, my lord, with all respect, my lord, that, my lord, parity may not prevail. Here, my lord, on merit also, my lord, on merit, my lord. On merit also, my lord, I stand on the same footing. Lordship, kindly have a look at page 15, my lord. Page 15, my lord. Page 15, para 4, my lord. Page 15, para 4, my lord. If I read between the lines, my lord, there is mention of a vehicle, AS11M. Lordship has found, my lord.
Yes.
AS11M 8582. Thereafter, I leave aside, my lord. Total 5 persons were in the vehicle. Out of that, one has been granted the privilege of bail. I am another one, my lord. Total 5 persons were in the vehicle. Introduction of the team members and independent witnesses was given to them. On asking, they introduced themselves as Manoranjan Das number 1, my lord. Thereafter, my lord, Sadiq Hussain number 2. He has been granted the privilege of bail, my lord. And thereafter, my lord, Robi Ahmed Borbhuya, another out of those 5, my lord. 4 is Gautam Singh, my lord. And 5th is myself, my lord, who is seeking bail now, my lord, Indra Kumar Bhattrai. So that the factual matrix is, my lord, we stand on the same footing, my lord. And my lord, regarding my lord, progress of trial, my lord, 4 are yet to be examined.
From 27 to 23.
And from 27 to 2023, it's almost a year, my lord. No witnesses have been examined till date, my lord. And my lord, on parity, my lord, there are several authorities, some say in bail. So far as bail is concerned, my lord, a fundamental right, my lord, parity may not be applicable. But there are also authorities, my lord, which says, my lord, with all respect, my lord, that in matters of bail also, parity remains intact, my lord. Now I am placing an authority, my lord, with all respect, my lord. Dhiraj Kumar Shukla versus State of Uttar Pradesh, my lord. With all respect, it relates to the year, my lord, 2022. There, my lord, I'm reading para Kiman.
Second.
I'm reading it and sorry. It has been placed before your lordships, my lord. Listen, man. It has been placed before your lordships, my lord. The authority. Dhiraj Kumar Shukla, my lord. There, paragraph 2, my lord. The allegations are that on a secret information, the police authorities intercepted 2 vehicles on 23/6/22, that is, one grey-colored Honda City car and second white-colored Swift Desire car. On an interrogation at the spot, Probin Maria, Puneet Maria, Rishabh Kumar Moria, Dhiraj Kumar Shukla were found to be occupants of the Honda City car, whereas the petitioner was driving the Swift Desire car. On taking a charge, more than 92 kgs of ganja was allegedly recovered from the Honda City car, whereas more than 65 kgs were recovered from Swift Desire car. Thereafter, 3, my lord. Para 3, my lord. It appears that some of the occupants of the Honda City car, including Parveen Muria and Puneet Muria, have since been released on regular bail. It is true that the quantity recovered from the petitioner is commercial in nature, and the provisions of Section 37 of the Act may ordinarily be attracted. However, in the absence of criminal antecedents and the fact that the petitioner is in custody for last 2.5 years, we are satisfied that the condition of Section 37 of the Act can be dispensed with at this stage. This much, my lord. So despite the embargo of 27, my lord, if it continues for, because then, my lord, Article 141 would be applicable, my lord. So
Basically, your submission is on long detention.
absolutely, my lord. Apart, my lord, the second is, my lord, that one
What
poet
was
is
your date of arrest?
same date of arrest, my lord.
23 to
23 to 20, my lord. 2020,
Yes.
20, no, 20, not 20, 2020, my lord.
কোর্টে রিজেক্ট করেছে বেলেগ কোর্টে ডে টু ডে ট্রায়াল করে দিয়েছে
Lordship, here out of 10 witnesses, 7 has been examined till date.
Six.
Seven.
না না আদি হাকি
Nine. Sota. 6.
Lordship, probably LCR is there, that can be confirmed.
It could be 7, my lord, doesn't make any difference.
Lordship, now my learned senior friend has argued that there is a co-accused has been granted bail. Lordship, I am relying on recent judgment, there is pronounced on 20th of November 2023. Lordship, may peruse paragraph 18 to 22. Although this is relating to PMLA Act, but the principle laid down by the Lordship note that is to be considered by your Lordship. And Lordship, with
Can I-
regard to allegation against the present petitioner, Lordship, page 43. Paragraph 18, 19, 20, 21, 22.
কোনটো authority তোমাৰ দিলা?
Tarun Kumar.
Matlab in Tarun Kumar, if I may, with all respect, my lord, Tarun Kumar relates to PM. I'm not saying act is different, the law will be different. I'm not saying that, my lord. It relates to PMLA, my lord. There, apart from, my lord, if somebody has been granted the privilege of bail, my lord, with all respect, my lord, the materials against each individual accused needs to be looked into, my lord.
You are
Have-
completely civil.
Have I made my position clear, my lord?
Yes.
This should not be applicable because of the reason, my lord. In the instant case, I first placed the factual metrics before your lordships, wherein it is clearly stated, my lord, recoveries were made from a vehicle. Recoveries were made from a vehicle wherein there were 5 occupants, my lord. If looked into individually as regards each accused regarding materials, my lord, there is parity on that, my lord.
Okay.
And my lord, my lord, prayer for bail is not primarily on parity, my lord. My prayer is undue delay, whereby Article 21, the constitutional mandate of Article 21 has been violated, my lord. Have I made my position clear, my lord? And thereafter, looking if, my lord, this authority is followed, although pertain to PMLA, even then, my lord, with all respect, my lord, material regarding each individual accused, the accused who has been granted the privilege of bail, and the present accused, they stand absolutely on the same footing, my lord.
Doesn't basically
My lord, that authority I have placed regarding 2 vehicles, that authority just now I have placed, my lord, with all respect, my lord, regarding NDPS, wherein recoveries were made from 2 vehicles.
Dhiraj,
Exactly, my lord. Even in that case, Apex Code went to the quantum of detention, my lord. Different factual metrics because one
okay,
car,
no, let
you-
Mr. Kyle submit.
Lordship.
This judgment says that individual, the role attached to the individual accused has to be considered.
Yes, Lord.
But then also they are on the same footing.
Lordship, may please to see page 43,
Of-
paragraph 62 of the bail application.
Para 62, yes.
Paragraph 62, Lordship.
Yeah.
Indra Kumar Bhattara is the accomplice of the accused, KSH Gautam Singh, who is supplier of methamphetamine tablet. On the direction of the accused, the accused Indra Kumar Bhattara brought the alleged methamphetamine tablets from Impal to Guwahati with driver Sunil Kumar in a truck. From the CDR analysis of the mobile of the accused, Indra Kumar Bhattara, it is found that he was in contact with suspected truck driver so-and-so. Accused has stated that his statement that they directed the accused in Mumbai to come to Guwahati in a truck with Sunil Kumar with methamphetamine tablet. Lordship, with regard to presence of the accused on the spot, there is a judgment of Honorable Supreme Court in the Union of India versus Nawaz Khan, Lordship. In paragraph
Here we see, no?
paragraph 30, I'm reading, Lordship. The following circumstances are crucial to for assessing whether the High Court has correctly evaluated the application for bail having regard to the provision of section 37. The respondent was traveling in a vehicle all the way from Dimapur in Nagaland to Rampur in Uttar Pradesh with co-accused. Then the complainant noted that the CDR analysis of the mobile number used by the respondent indicates that the respondent was in regular touch with the other accused persons who were known to him. The quantity of contraband found in the vehicle is a commercial quantity. the contraband was concealed in a vehicle in which the respondent was traveling with the co-accused.
No, what you want to say?
I want to say, my learned senior submitted that he was found in the truck, but nothing was recovered from him.
I never said that.
No.
No more goes to, no, I never said that. I'm sorry.
No, subject to correction. Lord.
No, I'm not saying that. I
No, without
only.
going into merits,
Huh.
the present petitioner was found in the same vehicle from where contraband was seized. One of the co-accused
Yes, Lord.
has been granted bail on the ground of prolonged detention.
In this Lordship, I want to place the judgment of Tarun Kumar. Lord. Here, Lordship, in also delay is also discussed, Lordship, in paragraph 29, probably 20.
Well, দুইটা বস্তু একেলগে পঢ়া না। My lord, I may place another thing. I have got highest respect for my friend, my lord. But my lord, in piecemeal manner he reads, my lord. He has shown the allegations against in Kumar Bhattrai, the present accused, before your lordship.
No, here we are not on merits.
Exactly.
The co-accused has been granted bail on the ground of prolonged incarceration. He is saying that I have also been detained behind the bar for similar period, exactly same or more than that. 3 years, 10 months, 27 days.
Both were arrested on the same day.
Yes, so his plea is that merely on the ground of prolonged incarceration, he
Lordship,
is also entitled to get.
in this case,
And their prosecution witnesses, my lord, they cannot produce. Court even issued warrant of arrest. Despite warrant of arrest, they are not appearing, my lord.
No, whatever may be reason, the trial could not be concluded.
Lordship, in my humble submission, in CRPC, nothing is stated that within which period a trial should be completed. In case of Muhammad Muslim, Honorable Supreme Court come to finding, although the ratio was laid down, that section 436 capital A will be applicable in case of NDPS also. But the maximum punishment is to be calculated. If he is in jail for more than half of the.
But in spite of that, Apex Court is granting bail.
Lordship, that I'll humbly submit that the three judgments, these are not you cannot stand to be a precedent, Lordship.
Why?
Because there were not judgment, there were order only. And recently, in case of income tax, Honorable Supreme Court has clarified what is the ratio decidenty and what is the ratio. Because it must be a judgment, Lordship.
My lord,
In Muhammad Muslim, yes, of course, there is a judgment ratio was laid down. That 436 capital A will be, but other three judgments, these are the 1 or 2 page orders where nothing has been discussed, Lordship. Although, yes.
what is the ratio, my lord, when reasoning is given?
Yes, Lordship, that is required to be given.
My lord, I don't know, my lord. Let us not go into academics, my lord. What I'm saying is this, my lord, with all respect and tolerance, my lord.
No, Mr. Mahajan, let him come.
Oh, I'm sorry. I'm sorry, my lord.
So this is my humble submission. And in Tarun Kumar Lordship, all aspects of the case has been discussed.
Where?
In Tarun Kumar case, Lordship. Paragraph 18 to 22, Lordship. And with regard to granting bail to co-accused, Lordship, that has also been discussed in this. Probably paragraph 19, Lordship.
The ratio of Tarun Kumar is, my lord, if somebody is granted bail, it is to be looked into whether they stand on the same footing, the merit of each individual accused vis-a-vis the bail order of the accused who has been granted the privilege of bail. That is the ratio of Tarun Kumar.
Lordship, consider and necessary.
Ratio is while applying the principle of parity, court is required to look into the individual aspect. of it.
Absolutely. There, my lord, kindly see.
Whether it stands on same footing or not.
Exactly, my lord. Exactly, my lord. Kindly see. He has shown one paragraph,
Okay.
para 62. Let me read para 61, my lord, more as regards the accused who has been granted the privilege of bail. You do not read it in a piecemeal manner, my lord.
And Lordship, some other paragraphs of the judgment that may also be perused.
This Tarun Kumar.
Yes, paragraph
My lord, my lord.
Okay, I'll go through Tarun Kumar.
18 to 22, Lordship.
Heard Mr. B.K. Mahajan, learned counsel for the petitioner, also heard Mr. S.C.K.L., learned standing counsel NCB. Let this case be fixed for delivery of orders on 19th. Tomorrow, tomorrow.
My lord, my lord.
Not sir.
Highly obliged. If for, my lord, academic interest, my lord, there is one judgment, Hussain, my lord, in NDPS cases also, my lord, article, all sessions cases are to be completed within 2 years, my lord. With all respect, my lord, even that authority is there, my lord. It has been cited in your lordship's order, my lord. So that cannot overrule anything else, my lord.
No, but that is not hard and fast. It is expected that everything, that criminal trial should be completed
My lord,
within.
lordship is very correct, my lord, but possibly the sale word has been used.
And
So what will happen if it is not completed?
Then I get the benefit, my lord. I get the benefit, not by acquittal, my lord, but only by a limited.
Conditional liberty.
Absolutely, my lord.
Lordship,
Absolutely, my
in
lord.
Manish Sisodia's case, Supreme Court has dealt with this aspect of the matter also. And court said that
Manish Sisodia is, my lord, you cannot draw a parallel, my lord. Manish Sisodia, 7 months only, my lord.
no, in that case, Lordship, Supreme Court has directed the trial court to calculate the dates on whose default the trial is delayed.
No, that's all right, my lord. First of all, let us go to the first original beginning, my lord, wherefrom I begin to run. It is 7 months, my lord. And here it is, my lord, 3 years, 10 months.
Okay, I'll go through records tomorrow.
My lord, highly obliged, my lord. My lord, when he comes, my lord, he reads so many things together because I am a man, a blunt man, my lord, this is very difficult to comprehend, my lord. Highly obliged.
Please, your lordship.
I'm sorry, Lordship, I was unable to attend when the matter was called launch.
Are you ready now, both parties? How much time will it take?
Lord, will take at least 40 minutes for me to, my lord, because
No, today we have time, but in second half, we also have another hearing.
I'll not take much time, Lordship. I think within half an hour, I'll complete my argument. At
Okay.
best, Lordship.
No, let us finish it today.
yes, ma'am.
Yes, Mr. Moore.
Now, my lord, the last date of hearing, if my lord may allow me to
Refresh.
brief up, yes, my lord, refresh what we have submitted. Now, my lord, the parliament was alive to a situation.
No, before that, you have to tell me about the gist of the case
Yes, my lord.
in very brief.
Yes, my lord. Gist of the case is, my lord, the petitioner before my lord, while he was working as a regional officer of NHI, he had a discharge of his official duties on the recommendation of the authority engineer and on the recommendation of the project director, has ordered the release of 2 bank guarantees of a contractor. The bank guarantees were to be released in pursuance of the contract executed between the contractor and the NHI, my lord. I am not the person who has settled the terms and conditions of the agreement. The terms and conditions of the agreement were settled between NHI and between the contractor long time before, my lord. So the allegation against me is that I, while in discharging my official duties, I had released 2 bank guarantees on the recommendation of the authority engineer and also on the recommendation of the project director. Project director is the person who is responsible.
No, by releasing what offense you have committed?
So now that is
What
not,
is alleged?
that is not, I am at my wit's end to understand they had filed the charge sheet also. I am at my wit's end to understand what offense I had committed.
No, but what has been alleged in the charge
Now,
sheet?
what they have alleged, my lord, what had happened, transpired is that two officials from the finance department of the NHI Guwahati were arrested, my lord, while accepting and taking bribes. Date is important, my lord, on 12/6/2022 from the same contractor.
12/6/22.
Yes, madam. 12/6/22. And these two officials of NHI and one official of the contractor who was arrested while taking and accepting bribes. The memorandum prepared by the CBI on 12th is on record, my lord. There is nothing against me in that contract, that trap proceedings, Panchnama, recovery memo prepared by CBI on 12th, my lord. So these two officials of NHI and the one official from the contractor were arrested. Now, my lord, there is no statement made by these two officials of NHI in regard to that they have accepted this money for my behalf or on my instructions or at my instance, my lord. It is not even the case of the CBI that the money was received on my behalf or at my instance or for I have anything to do with that. Now, my lord, on 14th, I was arrested by CBI, 14/6/2022. Another important aspect is, my lord, on 12th, they registered an FIR, that is RC. Instant RC was registered, and I am not named and accused in that RC, my lord. I am not an accused in the FIR registered. So on,
Now in that, there was a trap
yes, ma'am.
laid against two NSIDL officials.
Yes, ma'am.
They were found taking
Yes,
bribe.
ma'am.
They have not named you.
They have not named.
Then thereafter,
I will be out of the court
Thereafter-
if they have stated that this money was for me or this money had anything to do with me or it was accepted by them
then
on.
that FIR filed by the CBI,
Yes, ma'am.
RC,
Yes, RC.
what was the allegation in that?
Allegations was that they had misused their official position and for.
Those two or you also?
No, my lord, that is not against me.
Okay. Okay.
So now they, on 12th, they registered an FIR. On 14th, they arrest me. Now, what is important, my lord? As per the enactment, section 17A, the proviso says that the CBI could arrest, if I was arrested at the time of taking or accepting bribe, then they are not required to obtain permissions for investigation and carrying out investigation against me. Kindly see for a minute, my lord, section 17A. That was inserted by the parliament, my lord, in their wisdom, considering the fact that the official mechanism has come to an halt.
Mention of corruption. Yes, you read. sir.
And another important aspect that I wish to draw kind attention of this honorable court. My lord, on the day when I was arrested or on the day when the trial proceedings were carried out by CBI, as far as the release of bank guarantee was concerned, it was already done. There was no work of that contractor pending with NHI as far as I am concerned, my lord, with my office.
Now, how this release of bank guarantee and bribe from contractor is linked?
It is not linked, my lord. They says,
What they say?
my lord, they say that this amount was given to two
Release
officials,
the bank guarantee.
two officials for clearing the contract money. Bank guarantee has nothing to do with it. And secondly, my lord, very importantly, I have no role to clear their bills or their invoices. As per the official duties assigned to me, I had nothing to do with it. I was only to act on the recommendation of the authority engineer and also on the recommendation of the project director. Vis-a-vis the bank guarantee is concerned, my lord. The release of bank guarantee, the release of financial money bills or clearing the bills is concerned, my lord, I had no role. Even in their charge sheet, they had not stated so.
You were referring to section 17.
May I read below section 17? Inquiry or investigation of offences relatable to recommendations made or decisions taken by a public servant in discharge of official functions or duties. No police officer shall conduct an inquiry or investigation into an offence alleged to have been committed by a public servant under this act, where the alleged offence is relatable to any recommendation made or decision taken by such public servant in discharge of official functions or duties without the previous approval of, in case then it is, then my lord, very important, proviso, provided that no such approval shall be necessary for cases involving arrest of a person on the spot on the charge of accepting or attempting to accept any undue advantage for himself or any other person. So, my lord, I was not arrested accepting or attempting to accept any undue favor on 14th. So, the mandate was for the CBI to seek prior permission, approval from the competent authority.
So no prior approval under section 17A was.
17A, Kwame was obtained at any stage by the CBI before arresting me or before carrying out investigation against me. Now, it also very important to mention, my lord, that it is not even investigation. It is even at the stage of inquiry. They cannot carry out any inquiry against me without obtaining the approval. Then, my lord, they arrest me. I was released on bail by this honorable court, wherein it is specifically mentioned. May I place on record, my lord? It is specifically mentioned that there is no demand or by the petitioner, my lord. It is duly reflected in the order.
Yes.
It is specifically mentioned, my lord, only for a minute I will wish to, my lord, to read that operative part. Para 10(4), my lord.
Yes.
So there is no demand as far as I am concerned, my lord. Now, in the charge sheet, since they had arrested me in violation of certain provisions and judgment of Honorable Supreme Court also, in Until's case, my lord, there are judgment. Now what they say is, in their reply before my lord, they say that I could have raised objections to release of their bank guarantee. I could have done it. Now in their wisdom, they did not say on what account the bank guarantee could have been stopped. It was an obligation cast upon the NHI to release the bank guarantee, my lord. My lord, the bank guarantee is.
No, the release of bank guarantee was stipulated in the agreement.
Yes, my lord. It is
that on happening or not happening of
on
certain.
certain, my lord,
Yes.
certain act, it will be released on by the NHI.
And your submission is according to the stipulation you have released.
Yes, my lord. And when it was due and it was required to be done, and after following the due process, my lord, it was as per the contract. It was the duty of the authority engineer, my lord. This is the contract for 400 plus crore rupees entered into between NHI and between the contractor. Agreement was entered into in the year 2015, my lord. I was not a person who entered into this agreement. So the terms and conditions which were stipulated were required to be adhered to and required to be followed. If my lord will have clause 17, clause 7, 7(4) on page number 137, my lord.
Page
137, my lord. Clause 7(4), my lord.
release of performance security.
Yes, my lord. The authority shall return the performance security to the contractor within 60 days of the letter of expiry of maintenance period or the defect liability period under this agreement. Notwithstanding the aforesaid, the parties agree that the authority shall not be obliged to release the performance security until all defects identified during the defects liability period have been rectified.
Know what it means?
It means, my lord, if there were any defects, then bank guarantee will not be released unless and until those defects are rectified. Otherwise, after the expiry of the
60 days of
60 days, within 60 days, the NHI was required to release the bank guarantee. The defect liability period, my lord, in the instant case ended on 31st March 2022. So on 1/4/2022, the bank
So
guarantee
defect liability period ended on
on 31st March 2022.
Now, from where we can,
Yes, my lord, that
Concrete.
is my lord, duly reflected even in the charge sheet that they have filed.
okay,
It is duly reflected, and also, my lord, even in this, we have specifically mentioned there are documents to that effect that it was to be released on such and such day. So bank defect liability period was over on 31st March 2022. And in pursuance thereof, my lord, if my lord will have,
okay, one query. When you release these two bank guarantees,
yes, my lord.
on which date you have released?
My lord, it was released on, last bank guarantee was released on 9/6/2022.
9/6/2022.
Yes, ma'am.
And two bank guarantees were.
Two
there.
bank guarantees were released. One is, I would specifically mention the date, my lord. First bank guarantee was released. It is, if my lord will have the charge sheet filed by them. Where the dates are mentioned, my lord. If my lord will have page number 57 for a minute. My lord have 57
Yes,
in clause number 1620, my lord.
yes.
On at serial number 3, the release of performance bank guarantee amounting to rupees.
27/4/22.
Yes, one first was released on 27/4/2022, and then second bank guarantee was released on in at serial number 9, my lord. My lord will have.
9/6/22.
Yes, ma'am.
Okay.
And
When, one more query. When this trap was laid
yes, ma'am.
against, on which date?
On 12th of 12/6/22, my lord.
And you were arrested on 14th.
14.
Okay, now dates are clear.
Now, my lord, if my lord will have this clause 16 for 20 of the charge sheet, on the same page 57.
Yes.
That investigation disclosed that since so and so, following payments have been released to the contractor by the NHI, including release of performance bank guarantee. So that is what is their allegation against me. As far as the release of bank guarantee is concerned, that was within my duty. Rest is, I was not responsible.
Okay.
So now, my lord, bank guarantee is, if my lord will have contract for a minute. If my lord will have page number 175.
Yes.
Now, my lord, as per in the terms of the agreement entered into between NHI and the contractor, there is a specific clause regarding appointment of authority engineer. Now, my lord, the authority shall appoint a consulting engineer.
You are authority engineer.
No, my lord, I am an officer of the NHI.
Okay.
This is a independent engineers.
Will recommend.
Independent engineers are appointed by NHI to supervise the work carried out and to see and recommend the release of funds, and if there is any defect, to pinpoint that. So they are working as technical auditor of the project. NHI will not do the release any money
Without their recommendation.
without their recommendation. and then time is scheduled that every month their application is, the bills are forwarded by the contractor to the authority engineer, the independent authority engineer. The independent authority engineer will, after going through the requisite records and seeing the progress of the work, then they will recommend to the NHI, to the project director, concerned official, that is project director, regarding the release of the bills amount. And every month, the bills are put to the authority engineer, and the authority engineer recommend the release of money, and then the money is released. So the NHI is working on the recommendation of the independent authority engineers. And in the present case, about 9 crore rupees fee is paid regarding this project to the authority engineer, and that is also duly reflected in the charge sheet that is filed by the CBA. If my lord will have. Clause number 16(7) on page number 49. And 16.9 on page number 15. my lord.
What is 16.7?
16.7 is investigation. my lord, they say the tender was floated and awarded to Mr. GR Infra Project Limited by NHI for the such and such project. Total contract amount was, my lord, 468 crore. And then initially the bank guarantee was 7.5%. However, which was reduced during the corona period. That is also duly documented, my lord.
Now, what is the gist of this 16.7?
16.7 is that, my lord, in the year contract was awarded by the NHI. I was not a person who has anything to do with it. And furthermore, bank guarantee was 7.5% of the project. Contract price was to be fixed. Then, my lord, will have on page number, next page number 50. 16.9. Investigation disclosed that NHI has appointed a company, namely Messrs. Aegis India Consulting Engineers Private Limited, EGIS Tower so and so, Gurgaon, for monitoring and supervision of this above said project for initial amount of rupees 8.8 crore rupees, which was increased to 9.758. So now, my lord, my humble submission is neither I am party to enter into these two contracts. I am not the person who had appointed these contractors, nor the person who had awarded this contract to Mr. GR Infra Project. So now these engineers, Messrs. EGIS India Consulting Engineers Private Limited, they were to monitor and supervise the above said work, my lord. And my lord, then I will mention there are documents, there are contract, which is.
Mr. Moore will continue at 2.
Yes, ma'am.
At 2 will.
Yes, madam.
How long, how much time?
Half an hour more, my lord. I will continue.
You may be able to finish today.
Lordship, today itself will finish, Lordship.
We'll continue at 2.
Yes, madam. In the office note, my lord. On that I was reading earlier. So it is duly mentioned that the performance guarantee was recommended by the authority engineer, and after complying with all the requisite formalities, it was released. Then my lord, for 10 minutes I will take in rebuttal and after, and also go through the judgment, my lord, on the subject.
Lordship. Lordship, my learned friend has already narrated the entire incident, but certain facts which are to be disclosed before this honorable court is there. Lordship, this is a case where there are three sets of Lordship accused. One set of accused from NHI, second set of accused from Aegis, and the third from GR Infrastructure. The three sets, Lordship.
Your infrastructure is the
Private
contractor.
company. It's a company.
Aegis is the
Aegis is a consultancy.
consultancy.
And
They
Lordship-
work like auditors,
Yes, yes,
technical auditors.
yes, Lordship.
Okay.
They are like auditors. So here, Lordship, contract was awarded to GR Infrastructure. The contract award was 436 crore. There's a very big project in the state of Meghalaya, Lordship, for construction of road and all. And Lordship, while awarding contract, Lordship, they are supposed to pay, submit a bank guarantee, Lordship. 7% of the contract award. It was more than 35 crore, Lordship, 35 crore, the bank guarantee. However, Lordship, it was reduced by the authority and it was reduced to 13 crore, Lordship. They submitted the bank guarantee, Lordship. And after, Lordship, they have completed the work. Work, Lordship, was completed, Lordship. If your Lordship, on the last occasion, Lordship, this matter has been heard by Justice A.D. Chaudhary, Lordship. Justice A.D. Chaudhary requested us to place the relevant documents which supports the case of the prosecution, Lordship. I have supplied a copy of those relevant documents to them also. A copy of it is available with me as the matter was not listed before Justice Chaudhary. Then placing those records before your Lordship.
You have prepared an index of those documents.
No, only documents were sought for, Lordship. Only the relevant documents, statement of witnesses, and the relevant materials.
No, their case is simple case.
Yes,
Their,
simple.
their case, what I have understood
Yes.
is that he is an
Regional
official
officer,
of
NHI.
NHAI.
Right.
He was under contract with the
Aegis. Sorry,
the
GR.
NHAI and Aegis had a contract. Under the stipulation of contract, the bank guarantee is to be released to
Yes.
the contractor
Yes,
after a stipulated period of
Right.
time
right, Lord.
on some contingencies.
Right, Lord.
Like if there is maintenance is required
Lord.
after completion of the maintenance,
Right.
some 60 days or some time was
Yes.
given.
Lord.
His plea is that he has only performed his duty by releasing the bank guarantee.
Yes, Lord.
Had he not released the bank guarantee, their penalties are prescribed as per the contract. NHA would have to pay the penalty.
Yes.
And his second limb of argument is that the trap case where two officials of NHA were trapped by CBI, he is nowhere named. He is not linked with that trap case. So there is no material against him. That is, in nutshell, that is his case.
Right.
How you counter his case?
Lordship, I'll counter this thing by submitting that whether the accused has discharged his duty by releasing the bank guarantee within the stipulated period of time or not, Lordship. That is the vital question. Whether the time prescribed by the agreement has been followed or not, Lordship.
Yes.
If your Lordship sees the statement of the witnesses, Lordship, one of the witnesses stated, Lordship, the work was completed within such and such period. The work has been completed on 31st/3/2022. It was completed on 31st/3/2022. Lordship may kindly have it look in. And the maintenance period within 90 days, 60 days, as per the agreement, they will have to release the bank guarantee.
Yes.
Right, Lordship? When did they release the bank guarantee, Lordship? The first bank guarantee has been released on 27/4/2022. First bank guarantee within the 60 days period they have released. But they retain the second bank guarantee, Lordship. They retain the second bank guarantee, and after completion of this 60 days period, 9/6/2022, they have released the second bank guarantee. And the reason being, Lordship, it is quid pro quo for securing the job of his cousin, Lordship. There is a telephonic conversation which has been recorded and intercepted by the CBI, which says that, which will reveal, Lordship, that the present accused person, he had a nexus, he had a talk with the accused person, other accused person of the company GR Infrastructure for securing the job of his cousin, Lordship. If your Lordship, here I have collected the statement of his cousin also, Lordship. He has also admitted the same fact. Now, if Lordship sees section 7 of the PCF, it is not limited only to the pecuniary benefit, Lordship. Any undue advantage, Lordship. Any undue advantage, Lordship, after the 18th Amendment, Lordship, if your Lordship see section 7A, Lordship, of the Act, 7 of the Act, may I read, Lordship?
Yes.
Then it
Okay, any undue advantage is also,
is also an offense, Lordship. It is a gratification, Lordship. It is a gratification. It has been described in the Act itself, Lordship. What is?
but have you mentioned it in the charge sheet
Yes, Lordship.
that for this purpose he has?
Yes, Lordship. In para, Lordship, we have categorically stated in our charge sheet, Lordship. My learned friend has also shown the para where it has been categorically stated that for securing the job of his cousin, Lordship.
Mr. Haloi, what I propose, because we have two other matters listed.
Lordship.
I have understood the gist of the submission of the counsel for prosecution, the petitioner.
Yes.
And you, both of you give one sheet of paper
Lordship.
raising your points in bullet points.
Lordship, we have already prepared, Lordship. And placing before this honorable court, evidence against Alok Kumar, Lordship, on point wise, I have reflected in a.
Give a copy to him also.
I have
so
already
that-
supplied a copy.
So that he can counter.
I have already supplied a copy of all this document to him also, to the petition.
You have answered to his Mr. Mode. You have gone through his,
I'm Mr. Man Miller, Mr. Moore is very rude.
yes, what's your name?
Man, Mr.
Oh, yes, Mr. Man, sorry. No, we will continue with the hearing tomorrow.
Yeah.
Tomorrow or day after tomorrow.
Day after tomorrow is holiday. Tomorrow will be.
Tomorrow.
Tomorrow we will
Friday.
continue.
Make it, Lord, on next week, Lord, after 26. I have one serious matter in
Okay.
Delhi High Court, Lord.
Okay, we'll stop now.
Lordship.
You give your submissions in bullet points.
Lordship, I have already made a note of it, all the statement.
You also give,
Yeah, I have.
and we will continue on whatever date you suggest.
ये bullet point है
Heard, Mr.
submission.
What's your name?
Sanjay Man Miller.
Heard, Mr. Sanjay Man, learned counsel for the petitioner.
Nine,
Okay.
23rd. On 23rd, Lordship.
23rd is next week.
On 23rd, he done. No, 23rd, Lordship.
At 3 p.m.
At 3 p.m.
At 3 p.m.
Yes, ma'am.
Because I'll be having DB.
Lordship. The Lordship gives me half an hour, I'll come to Lordship.
On 23rd, because we. The hearing remain part heard.
Yes,
Let this matter be listed again on 23rd.
grateful.
May I place it on record, Lordship, these documents, Lordship?
Ah, yes. Learned counsel for the learned standing. Oh, okay.
On 23rd, shall I place or today, Lordship, these documents, Lordship? Is that-
You have prepared it,
Yes, Lordship.
then you may submit it. I'll record it. You have also submitted.
I have submitted. I have submitted bullet points and also below the brief submissions and also below few judgments.
Okay. Okay, then on 23rd.
Grateful, man.
Yes, Mr. Bail too much. Bail. You have to finish within 15 minutes. Mr. Bishas has, how many day you are behind the bars?
As on date, my lord,
The compilation বনাইছিলে।
2 years, 5 months, and 24 days.
In this case, you made a compilation of
Yes.
dates.
Yes, my lord, it's there.
No. আগৰ কেছ লিখক heard Mr. Sanjay Man, learned counsel for the petition. Also heard Mr. M. Halloy, learned standing counsel, CBI. Hearing remain part heard. Let this matter be, both the learned counsel have submitted brief gist of their written arguments. Let the same be kept in case record. Let this matter be listed again on 23rd January at 3 p.m. as a part heard matter.
Yes, my lord. My lord, let him, your lordship wanted to refresh that, how many days he's in custody, my lord?
No, how many days you are in custody?
As on date, my lord, because, every time I count it, it gets adjourned, my lord.
Yes,
So
now,
therefore, I had to again recount it. 2 years, 5 months, and 24 days. And if it is counted in terms of days, then as on date,
so basically, Mr. Kyle, his submission is also that he has been detained behind the bars. And what is the stage of trial?
Lordship,
Stage
out of 12 witness probably. Lordship.
out of 12 witness,
Three
3,
witnesses have been examined.
3 has been examined till date, Lordship.
and the last witness was examined on 23/11/2023.
23,
11/2023. And on 3/1/2024 was the last date. The same result, witness absent.
okay, what is your submission?
Lordship, here, Lordship, may please to see page 9. The recovery of ganja was 360.35 kg from the possession of present petitioner and one Javed Iqbal on 25/7/2021.
Recovery was from a vehicle.
Vehicle, where the petitioner was there. Lordship, come to page 11, paragraph 6. Paragraph 6 and 7, it is stated how the contraband was seized. At about 3:30 hours on 25/7/21, one truck number so arrived at Narayana Super Specialty Amingaon and was stopped by the NCB team. There were 2 persons inside the truck. The team immediately rushed towards both the persons, requested them to get down from the truck. Introduction of the team were given to them, showing department identity card by NCB team. On asking, they introduced themselves as Sanjay Kumar Saha as a present petitioner. As it about so and another person was Javed Iqbal. So from their position, it was seized. And final complaint was filed on 17/1/2022. Charges were framed on 10/6/2022. Lordship, in the morning hours, I've submitted one judgment of Tarun Kumar. I'm relying in the same judgment, Lordship, paragraph 20. I'll supply again a copy, Lordship. Today I'm not there. Lordship, I'll want to read two paragraphs on Lordship. It is very important. Although this case was related to PMLA, but same provision is there. In that act, it is 45. Here it's 37.
Para 20.
Paragraph 20 and 21. Married Lordship.
Yes.
It is also difficult to contest the submission of the learned counsel, Mr. Luthra, that the investigation the appellant is complete and the trial of the case likely to take long time. According to him, the appellant ought not to be incarcerated indefinite merely because the investigation is kept open and regard to the other accused. In this regard, it may be noted that the appellant has not been able to overcome the threshold stipulation contemplated in section 45, namely that he has failed to prima facie prove that he is not guilty of the such offense and is not likely to commit any offense while on bail. It cannot be garnished again said that the burden of proof lies on the accused for the purpose of condition set it out in section 45 that is not guilty of such offense. Of course, such discharge of burden could be on probabilities. Nonetheless, in the instant case, there being sufficient materials on record adduced by the respondent showing that the thick involvement of the appellant in the alleged offense of money laundering under section 3 of the said act, the court is not inclined to grant bail to the accused. Next paragraph. The apprehension of the accused counsel, learned counsel for the appellant is that trial is likely to take long time and the appellant would be incarcerated for indefinite period is also not well founded in view of the observation made by this court in the case of Vijay Mandal on application of section 436A of the CRPC. It has been categorically held therein that paragraph 419 of that judgment, section 436A of 1973 code is wholesome beneficial provisions, which is for effecting the right of the speedy trial granted under Article 21 of the Constitution, and which mere specifies the outer limit within which the trial is expected to be concluded, failing which the accused ought not to be detained further. Indeed, section 436A of the code also contemplates that the relief under the provisions cannot be granted mechanically. It is still within the discretion of the court, unlike the default bail under section 167 of 1973 code. Under section 436 of the 1973 code, however, the court is required to consider the relief on case-to-case basis, as the provisions therein itself recognizes that in a given case, the detention cannot be continued by court even longer than half of the period for which reasons are to be recorded in writing, and also by imposing such terms and conditions to ensure that after release, the accused makes him or himself available for expeditious completion of the trial. So this is the latest judgment of November 2023, Lordship. And Lordship has considered many judgments. Only Muhammad Muslim, I mean, my humble submission, the ratio has been let down. But in another three orders, nothing is let down in my humble submission. No ratio has been let down, Lordship. So it cannot be said that completion of 2 years or 3 years is a delay of trial, Lordship.
Okay.
So in my humble submission, Lordship, Lordship may direct the trial court to complete the trial.
Okay. Mr. Bishas, do you want to respond?
Quick response, 5-minute response. In fact, Torun Kumar is not a judgment based on NDPS Act. Now, if Torun Kumar is relied in an NDPS Act, then I will rely Sanjay Chadda versus CBI 2012 1 SCC page number 40 if my memory does not fail me.
What it says?
It says that after charge sheet, because my lord, since he is coming up with judgments not related to NDPS Act, then my lord, I have better judgments to rely on in case of charge sheeted bail, my lord. I was confining myself to only those judgments which were decided at the backdrop of section 37 of the NDPS Act. That was my entire NDPR, my lord. Your lordship has seen all those judgments, my lord, I don't want to waste. My lord, further, my lord, in Torun Kumar, whether there is any paragraph in Torun Kumar which says that 19 adjournment is permissible in trial court and 4 adjournment is high court. I have given a chart, my lord, on the other day. That chart shows that they 19 times they failed. And they scored one more, now it is 20 times because, my lord, I am told that on 17/1/2024, also their witness did not turn up. Torun Kumar is on a different platitude, my lord. It is a
What is there in Sanjay Chadda's case?
Sanjay Chadda's case, my lord, this is the 2G scam case. It was a huge monetary scam, my lord, your lordship is aware. In 2G scam case in Sanjay Chadda, paragraph 20.
No. The submission of learned counsel for the NCB, that as the provision of 436A is there, where after completion of half the period of sentence prescribed for an offense, you would automatically get bail. Therefore, though he has not submitted, prolonged incarceration cannot be lesser than that period.
My lord, I
On that
understand. That is, my lord, I had, my lord, in my compilation, I had submitted as many as 13 judgments, my lord. In my compilation.
Yes.
In all these 13 judgments, both by the High Court and the Supreme Court, my lord, section 436A was there in the statute books. 436A is, my lord, it is a right which accrues, and 436A does not control 439. Otherwise, my lord, in all cases, an invariable submission will crop up that no, he is not, because there is 436A. Because 436A is not only confined to NDPS Act or for that matter PMLA Act. 436A is in relation to all offences, both IPC and other acts. So, my lord, if 436A is taken as a bar or embargo to grant bail under 439, my lord, in my respectful submission and limited understand probably,
And Apex Court has granted bail
in all these cases,
where the accused was facing trial for
1.5
possessing-
year, 2.5 year, 3 year. Our High Court have considered, my lord, 2 years, 2.5 years, 5 years, because, my lord, and my lord will see. 12 witnesses.
Okay, no, what is your submission regarding the counter submission regarding the submission made by the learned counsel for NCB, that in those cases where Apex Court has allowed the petitioners to go on bail, it has not laid down any ratio.
My lord, I cannot pass a comment on the wisdom of the Supreme Court, my lord. It is in clear terms, my lord, we'll see what the language which the Supreme Court has used, my lord. In one case, Supreme Court has said, because I have shown, my lord, where our High Court has rejected the bail, relying on Mohit Chawla and others, my lord. Then the Supreme Court has laid down that since we are granting bail in similar matters in other cases, why should these gentlemen be deprived of? I have laid down. There also the incarceration was not more than 2 or 2.5 years,
Yes.
hardly. Then in one case, in the other case, my lord will kindly see page number 4. Here, the second judgment here, 2.5 years, Supreme Court says, in the absence of criminal antecedent and the fact that the petitioner is in custody for last 2.5 years, we are satisfied that the condition of section 37 of the Act can be dispensed with. Page number 4, para 3, the last 4 lines. Now, my lord, I don't have the wisdom or courage to add meaning or to subtract any, my lord, any notion which has been expressed in these lines, my lord. It is in clear terms, it is saying, however, in the absence of criminal antecedent, here also, my lord, there is no criminal antecedent. And the fact that the petitioner is in custody for last 2.5 years, we are satisfied that the condition of
And
section
in
30.
Ravi Prakash case,
I'll come to Ravi Prakash also, I am relying, my
Supreme
lord.
Court has clearly
Clearly said.
said.
Let him complete, Lordship.
Supreme Court has said, my lord. My lord, this Torun Kumar, my lord, it is under a PMLA Act, my lord.
Okay.
Now, because, my lord, there are, and now, my lord, I have not bought this PMLA Act. Yes, sir, section 44. But a submission was made. My lord, I'll have to confirm. Without confirmation, my lord, I'll not make the submission. No, but lord, I have said, because if Torun Kumar is relied on, then, my lord, Justice Krishna Iyer, bail is the general rule and denial is an exception, can also be relied on. So these are, my lord, have seen. Moreover, my lord, that Anjan Nath, that case which was rejected by our High Court, my lord, page number 5, my lord will see.
Okay, Supreme Court granted.
Supreme Court granted. Now, all those Tarun Kumar was, these are more recent judgments. These are more recent judgments, my lord. All those, my lord, Tarun Kumar and section 37, my lord, there was one judgment of the Supreme Court, my lord. The other day, the counsel for the NCB was also there in before Justice A.B. Chaudhary, my lord. A batch of bail matters came up, my lord. Now, my lord, while making submission on expeditious trial vis-a-vis bail, one judgment came up which says that section 37 is there in the statute book so that it is only there in order to ensure that there is expeditious trial. The justification of section 37 is expeditious. If the trial is delayed, section 37 is diluted to a great extent. Because you cannot deny, at the end of the day, my lord, in NDPS Act, the percentage of conviction of your
Okay.
lordship is aware.
Also,
Is
the
that-
binding effect of the order. I'm reading one paragraph. It is relating to income tax, but here Lordship Court, Honorable Supreme Court has discussed what is the ratio decisionity, what is the ratio. Paragraph 18, I'll submit to your Lordship. The doctrine of binding precedent helps in promoting certainly and consistently in judicial decision and enable an organic development of law, besides providing assurance to individual as to the consequence of transactions forming part of daily affairs. Thus, what is binding in terms of section 141 of the Constitution is the ratio of the judgment. And as already noted, the ratio decisionity of a judgment is the reason assigned in support of the conclusion. The reasoning of judgment can be described only upon reading of the judgment in its entirety, and the same has to be called out thereafter. The ratio of the case has to be deduced from the facts involved in the case and particular provisions of law which the court has applied or interpreted, and the decision has to be read in the context of particular statutory provision involved in the matter. Thus, an order made merely to dispose of the case cannot have value or effect of binding precedent.
Okay, give that to me.
Yes, I'm giving. Paragraph 18.
Okay, heard Mr. M. Vichas.
15 seconds, only 10 seconds, 10 seconds. My lord, this judgment helps me because this judgment, when the council was reading, this judgment says from facts and particular statutory provision of the case. So the particular statutory provision is PMLA and my cases are on NDPS. So this case helps.
That judgment is in which?
Income tax.
With respect to income tax. I am submitted this judgment only just to show because
Precedent, how
exceed
to find out ratio?
Yes, Lord.
precedent.
and in all these three orders, nothing has been considered by the Honorable Supreme Court with respect to case of this. And in Ravi Prakash Lordship, we are pleased to see that he was arrested while he was a co-passenger in a truck and he was in jail for 3.5 years. And here, Lordship, the contraband was seized from his position.
No, he was also in the truck.
So, Lordship, this is the problem with my learned friend, Lordship. I'm not hiding anything. It is on the record, Lordship.
It is from the truck.
It is if it is seized, this is conscious position, Lordship. There are so many judgments of this. And Nawaz Sharif is the latest judgment on this regard, Lordship.
Ravi Prakash also from the vehicle. This is also from the vehicle.
Mr.
And
M.
he was
Vichas.
the driver of this vehicle.
How- I have heard.
Yes,
both
Lordship.
of them.
I'm obliged.
Let this case be listed for delivery of orders on Monday.
I'm deeply obliged.
Monday, that is 22. Remember? Yes, Mr. Chaudhary. You have 15 minutes.
No, Your Honor, I cannot do it, Your Honor. Because I am the first matter, it is not yet complete. Second, third matter, three matters. are there.
Today is your 4th day.
But I have been, I'm not getting, the question is, I'm not getting a hearing, Your Lordship. So this matter takes
No,
time.
Miss Sukre, what should we do?
Yes, Your Lordship, he has been taking so much time.
Because unless it is heard today,
Yes, Your Lordship.
and release it from part heard.
Yes, exactly, Your Lordship.
Your Lordship has heard
He's
it.
taking so much advantage of this court, Your Lordship.
Again, problem will come again, the whole cycle will start, Your Lordship. Let us start the matter, Your Lordship, because on 4 occasions, it was not my fault, Your Lordship. First occasion,
How much time?
it will take some time, not, it will, at least I think 2 hours.
Ooh.
At least 2 hours I'll take.
Otherwise, Your Lordship is a very simple, whether we have to
It's
see.
not a simple, for her, everything is simple.
No, Your Lordship, we are only on the question
There
of
has to
law,
be-
not on the facts
because
of the case. Only on the question of law.
We have kept it part heard and we are hearing it since September.
Yes, Your Lordship.
There was not a single date when the hearing took place,
Yes,
Your Lordship.
because of the fact that matter pertains to Kohima and we are taking it up.
Your Lordship, let us finish, start the matter, let us see, Your Lordship, can be done, Your Lordship. Let us start the matter. Let us start the matter, Your Lordship has heard some portion, let us start the matter, Your Lordship. Because seeing in a short matter is a question, I have to get justice, Your Lordship. He has retired from service, he's still criminal case, civil disciplinary proceeding carrying on, Your Lordship. He's in the,
No, I am not on facts.
no, Your Lordship, the question.
I am on the question, how much time will you require?
2 hours, I'll take that. 2 hours, at least 2 hours. 2 hours.
We don't have 2 hours. but-
Yes, Your Lordship.
25th, Your Lordship, 25th, I'll do to finish it up. 25th, today we'll start 25th. 25th, Your Lordship.
Yes, what do you say, Ms. Sukri?
Lordship, we have to cut the matter short. We can only go on the
Let her-
question
let
of
her
law
go.
only, on the question of law only, whether CBI inquiry is permissible or not, whether the question of the FIR is permissible or not, only on that question, Your Lordship. We cannot go here and there, hearing on all the allegations of the facts.
Cannot dictate what I should argue. She cannot dictate what I should argue. I know my case. For her, everything is simple because she has done everything. Bungle, the whole CPC has been, CRPC, everything has been bungle, Your Lordship, you will see.
No.
Charge sheet taken
no,
and withdrawn, Your
Mr.
Lordship.
Chaudhary, I am not on that.
Your Lordship,
I am on the question that this is a matter
Your Lordship,
of Kohima bench.
Your Lordship, yeah, I know that.
By
Your Lordship.
chance, we heard it when I was in Kohima
Yes, Your Lordship.
with
Your
a hope that you will finish it. It
I
was
told, at
carried,
that time also, I told I'll take at least 2 hours. I told that at that time also. On the last occasion, I told 2 hours, I'll take.
then you finish it, your part by
No,
4:15.
It won't be possible, Your Lordship. It won't be possible. It won't be possible. I'm saying judgments are there. Everything I have to rely on the judgments also. Judgments are there. Everything.
Then
is-
I'll release it
No,
from.
Your Lordship, let us start up.
No.
Let us start this matter, Your Lordship.
Then
Yeah,
I'm
because-
releasing it from
No,
part.
Your Lordship, let us start the matter, Your Lordship. Otherwise, it will create.
If I don't see a hope of culmination of your hearing,
Exactly, Your Lordship, yes.
then I'm
They,
not.
they want to delay the matter. That's the whole thing, Your
No,
Lordship.
we don't want
They
to delay the
matter.
matter, we want to
That's the
dispose it
reason
at the
you-
earliest, Your
you-
Lordship.
Question, let us finish the matter, Your Lordship. I am not getting a hearing, Your Lordship. On first day, Honorable Justice Sandeep Mehta retired, that date gone. Second day, that link didn't come up. Third day, this thing, Your Lordship. I am not for at fault. And the holidays were there, so it can be 18th, Your Lordship.
Tomorrow, will you be available?
I'm
Ms. Sukri, will you be available?
Lordship, today I'm not keeping well, so I don't know, I'm having cold, so I don't know about my health conditions for tomorrow, yes.
No, if we see any hope that we can finish it at least by next week, then I will hear it.
Yeah, I will finish it.
Otherwise, I will not
I
hear
will
it.
finish
So,
it.
Your Lordship, my prayer is that if at all, my learned friend, Mr. Chowdhury, could finish today, Your Lordship,
How
because
can I
he
finish
had,
it?
Let her suggest.
yes, he had submitted so much on the earlier occasion also, all the time he has taken,
Let her submit.
yes.
Yes, what do you suggest?
So my suggestion is that I request my learned counsel to complete his submission today so that at least we could come to
Okay,
a
thereafter,
conclusion, Your Lordship.
when can we hear it? On,
So if he could complete it today, Your Lordship, we can hear any date next week, Your Lordship.
when will be convenient for you?
I'm there next week. also.
For me, to no problem for me.
Next week, I'm there, Your Lordship.
20,
I have to finish the matter and go here.
Okay.
Because I'm reading that
Then
thing
let
again
us
and again,
start.
Your Lordship.
23rd. এতো চেঞ্জ করি।
Which is a very interesting matter. That's why
23rd.
I'll
We'll continue on 23rd. Okay, start. Record and send. We'll be very strict on time.
Yes.
You prayed for 2 hours.
at least 2 hours.
So you will get 1 hour 15
No,
minutes.
that cannot be.
Let me complete. 1 hours 15 minutes today and remaining part on
No, I'll
23rd.
try to. I'll try to assist you all because this is a very complicated matter. It's not an easy matter because whole thing
No,
is.
if it is very much complicated, I will release it from.
No. Yeah,
If
Your
it is
Lordship-
so complicated.
No, Your Lordship, it will take some time, Your Lordship. It will take some time.
Yes, please.
Because Your Lordship, what happened? There was a complaint,
Which one you are taking up?
read petition 11 for CBI inquiry and registration of FIR.
There was a raid
Yes, Your Lordship.
in
And-
which some contraband was
Yes, Your Lordship.
seized.
Yes, Your Lordship.
And
It-
you were the SP.
No, I am the IGP, not SP.
You were the IGP at
IGP, Your
that,
Lordship.
that time.
Yes, Your Lordship.
And the allegation is that on your directions, the accused was not arrested.
Yes, Your Lordship. That is their allegation.
That was the allegation.
Yes, Your Lordship.
From
But-
that you start.
Your Lordship, the issue is that those prosecution witnesses have been made accused, those accused have been prosecution by DP also. Their whole thing is crumbled by their own thing, Your Lordship. The issue is, Your Lordship, a written FIR complaint was given on 3/8/2018, Your Lordship. Till today, no FIR has been registered. And the accused are, the drug peddlers are going scot-free and they are in the good books of these people, Your Lordship. That's why, Your Lordship, question is because police officers are involved. This whole case was posted to save some police officers who were linked up with the drug peddling, Your Lordship. The whole case is that. Now, Your Lordship will see question of this 3/8/2018. That's a written complaint, Your Lordship. Written complaint was there. Then a seizure memo was on 3/8/2018 also was there. The drugs were seized. This 3/8, Your Lordship, the drugs and no FIR was registered till today, Your Lordship. Now, what I'm saying, Your Lordship, after that, they make an allegation against me that the drugs which are seized are kept in my custody. That's the allegation against me. They put all this PC Act, everything on against me. Nothing has, Your Lordship. The question is here, Your Lordship, how the drugs have come to them. That is not been investigated, Your Lordship. So that's why that complaint is very much necessary. That's why the moment that is registered, all these people are in difficulty, Your Lordship. And there cannot be.
Now, in this writ petition criminal, what relief you are?
I am seeking that registering of that complaint as an FIR and transferring the investigation to CBI, Your Lordship. This matter has not been investigated by the present case, Your Lordship. This, and the judgment to that effect also, the apex court also, two judgments are there. Even one judgment of this High Court also, Your Lordship, regarding that. They are registering the FIR and transferring the investigation to CBI, Your Lordship. That's a prayer in this writ petition, Your Lordship. Because nothing has been done on this complaint, Your Lordship. It was lodged by one of the prosecution witness has written complaint PW4. He has raised a written complaint after seizing the thing. That is still today not been registered. Nothing has happened to them. Because, Your Lordship, I was placed under suspension on 25/10/2018, Your Lordship. After that, nothing. Why? Suppose assuming but not admitted, I have prevented them. What happened after 25/10/2000? Why they have not registered the FIR against these people? Drug peddling. How the drugs has come to you? The source of drugs coming to you is not there. And you are kept in custody. From where the drugs are, the chain is totally missing. It is originally kept there. And all, if your Lordship will see the investigation also, nothing is on the charge sheet doesn't say anything about why not registering, not allowing registering the FIR
Who lost this complaint
complaint?
on 3/8? You have lost
No,
this.
not me,
Who?
not me. It was lodged by your lordship, the commander who has seized the people, who has caught up the
Okay.
commander. He's PW4 in the criminal case, your lordship.
Okay.
That is,
Where-
that is page, I just gave you the page, your lordship, that is the page
Where is,
38,
where is that complaint?
page 38, if your lordship, annexure P1. With reference cited, I have the honor to state that on 3/8/2018 at around 8:30 hours, one vehicle Maruti Swift white color registration number so and so was signaled to stop for checking by the duty personnel of Kujama local
No,
plaza.
this was lodged by the
Yes. Yes,
commander of narcotics.
yes. He's
Checkpoint.
PW4 in my case, criminal.
Before the officer in charge.
Yes, officer is at SP.
Now,
here.
what is the status of this complaint?
Nothing. No, it is not been.
No police station case was registered.
Nothing. That's why. And there is Caesar memo also is there. Next is the Caesar memo. Caesar memo, nothing has been done on this. In fact, the investigation done against me, the charge sheet are not related to these matters at all. So Lordship will see. Then the next is annexure P2 is the page 42, the Caesar memo, your lordship. 3/8/2018, your lordship. This
When-
drug test says your
When
lordship.
the
See.
seizure was made?
3/8, that same day, 3/8,
On-
2018, your
Okay.
lordship. Unfortunately, these documents are not part of the record of the charge sheet, your lordship.
Now, on this complaint, nothing was
Nothing
done.
was done.
Thereafter?
Nothing, because what happened, then what happened,
Thereafter, FIR against you,
FIR against me was, because
when,
that was on 1/9/2018, your lordship.
on the allegation that you kept the
What happened?
seized.
The allegations are that I kept, this was kept in my custody. Because there are no security, that it was kept in my custody. They said, I asked for it. They said, but dates are also disputed. I come to those things also. Question is, kept in custody of this thing. And I have been charged of 409, 420, PC Act, every PC Act, or even NDPS Act. Your lordship, where you have kept in custody and you have taken, the moment you came, another second seizure was also there. They again, if your lordship, you have seized the material, how can there be second seizure? That will be second seizure. It has to go out of your custody. The second seizure will come. You have asked me, admittedly, the drugs are in your custody of the police station. Your allegation is, I have taken it home. Then when you went, I gave it back. So when is the question of reseizure? Again, second seizure, how can the second seizure come? When the drugs are in the custody of these people also. So there cannot be second seizure, your lordship. Second seizure is 1/9/2018. And the seizure was made by the OC, who is another accused against whom investigation was, and he was acquitted. And on prosecution witness is one of the another accused, your lordship. So the seizure memo has contained co-accused with me. So see, how can that be a seizure memo, your lordship? Second seizure memo. If your lordship sees a second seizure memo also, it's here, your lordship. Page 68. It's
No, one more query. The FIR which was formally lodged
yes, your lordship.
on 1/9/2018.
Yes, your lordship.
There, this aspect was not investigated,
No,
the
no.
original
Nothing.
seizure.
Nothing. Even charge sheet in front of, I'll show it from there. The records have come. I'll show it from there. These are not, they have not referred it at all.
Okay.
Although in the charge sheet, the document was included that only that FIR at the criminal complaint, but nothing has been done. But the seizure memo has been avoided. There's the first charge sheet that has been taken away. The two charge sheet was there. Question is here, first charge sheet was taken back from the court. Then again a prosecution sanction was taken. Second charge sheet was filed. And the record the first charge sheet and the first sanction order is missing.
Okay.
So these are the glaring things I'm telling. Then your lordship will 173 section 173 section 173 will come. How could I investigate the matter again? In my case, once you have submitted a charge sheet on 22/11/2021, you take it back on 15/12/2020. I take it from the court, custody of the court. And then when I filed that the third writ petition, the criminal petition takes care of all those things. The whole thing that if the whole chain comes out, then your lordship, what happened? You take back, then you apply for fresh sanction again. Apply for fresh sanction, 2 sanctions order again, and you have suppressed the fact that the first sanction is and another sanction, then the third charge, second charge is come. So where is the provision in law that you can have 2 sanction orders? Different sanction, 2 charge sheet, and you cannot take from the custody of the court the charge sheet from the court, your lordship. They fought that there, and they have not replied to my quashing petition at all. They have not filed reply. No averment against my this criminal petition 27. Nothing. They have not filed. They have not denied it. And the drugs, after they seized from me, the drugs which was taken from me, your lordship, on 198, that was kept in their custody. And when I moved the bail application on 5/11/2018, I provided the court that the drugs are still in the custody. The court directed UC was there. So for 2 months they kept the drugs. So it is violation 102 CRPC. How they kept the drugs for so long? And now CFSR report comes, there's nothing trace. CFSR report is not supporting them also.
What CFL?
CFSR report is also there. That all the things have to, because that's why I think it's 6 hours time. The CFSR report.
Okay, you start.
Yeah. Now I'm just on this, your lordship, because I'm just giving a broad outlook what has happened, your lordship. Then your lordship, what happened? Then
You go one by one.
I'll go on.
Writ petition-
Let us finish this first.
Writ
Otherwise,
petition criminal first.
yes, sir. So, your lordship, criminal complaint was there. It was not registered and FIR, your lordship. Then your Supreme Court judgment is there. I was going through Lalita Kumari's judgment, your lordship. That is 2014, 2 SCC, page 1. I started on the judgment only, your lordship, on the last occasion. So, your lordship, well, lordship, I take your lordship page para 49 of the judgment, page 35, your lordship. What is section 152? Consequently, the condition, your lordship, another point I made to point out, your lordship, what they have done. So, lordship, just broadly, I say, 161 statement was made by his witnesses. Then they made 164 statement against me. That was 164 statement against me, and on that basis, the charge sheet was filed. Your lordship, who can make 164 statement? The accused or a person who is there. If you make it is what the 2 out of 4 people have made 164 statement. They come under 164, 2 of them come under 164.5. The 164 statement, 2 are the co-accused. They put all the claims on me, and it is barred by the Evidence Act also, section 30. So these are the things I have to, that's why I said it will take some time. I'll just finish it because it is a very interesting case, your lordship, where a new criminal law has been developed here. So, your lordship, what I am saying, your lordship, para 49, consider a condition signing out recording a FIR under section 150 is that there must be an information, that information must disclose a cognizable offense. They have not stated it has not disclosed a cognizable offense. If any information, my lord has got page for para 49.
Yes.
If any information disclosing a cognizable is laid before an officer in charge of police station satisfies the requirement 154(1), the state police has no other option except to enter the substance of the prescribed form that is to say to register a case on the basis of such. The provision of section 150 is mandatory, and the officer concerned is duty bound to register the case on the basis of information disclosing cognizable offense. Thus, a plain reading of section 154 of the code gives us this thing. Shall say. The use of the word shall in 164(1) code clearly shows that legislative intent is mandatory to register an FIR if the information given to the police or disclose a commission of cognizable offense. There is no doubt that it is not a cognizable offense. Then para 54, therefore the context in which the word shall appears in section 154(1) or the object for which it has been used and the consequence that will follow from the infringement of the direction to register an FIR, all these factors clearly show that the word shall used in the section 154 need to be given its ordinary of being of mandatory in character. The provision of section 154(1) of the code read in the light of statutory scheme do not admit the conferring of any discretion on the officer in charge of the police station for embarking on the preliminary inquiry prior to the registration of an FIR. It is a settled position of if the provision is unambiguous and legislative intent is clear, the court did not call for any other construction. In view of the above, the use of the word shall coupled with the scheme of the act lead to a conclusion that registered intended if an information relating commission of cognitive is given, then it would be mandatory to register an officer in charge of the police station. Reading shall as contended by some counsel would be against the scheme of the code. Section 154 the code should be strictly considered as a word shall should be given a natural meaning. The golden rule of interpretation can be given to go by in cases where the language of section is unambiguous. Then para 57 is still okay. It is the content of the AG appearing for the state of so and so recording the first info section is the book is subsequent at the entry of general diary, station diary and daily diary which is maintained in the police station. Here the GD entry has to be made by them, not by me. The OC. He has not made it. Merely putting an allegation. These are all oral allegations. I just stopped them. There is no such allegation or where there are in fact the service. Central Civil Service rules also, if there's an oral instruction that has been in writing, that should be. I'll point out to service rules also. Because here you understand, they said merely on telephone, I said you don't register. The OC is SP, not an inspector. OC of the police station is SSP, senior, and she's an IPS officer. It is not an ordinary, ASI also who is manning the police station. It's the SSP who manages the police station. And the special. So your lordship will see it is said generally so which it is on the document earlier said a general diary then any preliminary is needed to a police may conduct the same that information will be registered in FIR. The interpretation is wholly unfounded. They have rejected this. The first information is in fact the information that is received the first point of which is either given in writing or reduced in writing. It is not the substance of it which will be entered in the diary prescribed by the state government. The term general diary also there in some cases is maintained not under section 154 of the code, but under provision section 44 of the Police Act 1861 and states which applies to it. Then 58, they 44 police officers, this state mandatory. 58, they quoted the section 44. It shall be the duty of every officer in charge of a police station to keep a diary in such form as shall from time to time be prescribed by the state government and to record therein all complaints and charges preferred, the names of all the accused persons arrested, name of complainant, so and so. So then your lordship, I take your lordship para 59. Says it is pertinent to note that year 87, which is for Police Act was passed, the Code of Criminal 87 was also passed. Section 139 of the code, which is daily registration, and this section has also been referred. The word diary, as can be seen by language of so and so. So this is there. Then I come to your lordship, para 63. It is clear that registration of FIR is to be done in a book called the FIR book or the FIR register. Of course, in addition to list of the FIR or substance of the may be also made subject in the general diary as mandated in the Act Police Act rules as the case may under the review. 64, para 64. The general diary is recorded all important transactions, even taking place in a police station, including departure, arrival of police staff, handing over, taking over charge, arrest of person detained in law, or visit of senior. It is in the context that the substance of each FIR being registered, the police is also mentioned in the general diary. Since the registration of FIR also happens to be a very important event in the police station. Since the general is a record that is maintained chronologically on day-to-day basis on each day starting with the general diary reference also mentioned the summit of FIR. Then your lordship, I take your lordship to next. Then your lordship, I take your lordship to 73. Your lordship, para 73. Para 73, your lordship. Para 73 talks of information, your lordship. The legislator has consistently used the word information in section 154 as against the expression used in section 41A and G of the expression used in arresting without a warrant or reasonable complaint. The expression 154 is a quote not qualified by the prefix reasonableness or credible. The non-qualification of the word information in section 154, unlike section 41 is for the reason that police officer should not refuse to record any information relating to commission of a cognitive to the ground that he is not satisfied with the reasonable credibility of the complaint. In other words, the reasonable credibility of the information is not the condition for registering an FIR. Then your lordship, I take your lordship to para Ramzan Narang, I guess, your lordship. Then I take your lordship to para 83, your lordship. 83. In terms of the language of section 150 of the police is duty bound to proceed and conduct in the cognizable affair even without receiving any information. This is very clear, your lordship. About the commission of such an offense, if the officer in charge at the police station otherwise suspect the commission of such an offense, the legislative intent is therefore quite clear that it ensure that every cognizable offense promptly investigated in accordance with law. That being the legal position, there is no reason that there should be any discretion or option left with the police officer, register or not register, whether information given about commission of a cognizable offense. Every cognizable offense must be investigated promptly in accordance with law and all provided in section 150 of the code about the commission of a cognizable offense must be registered as an FIR or the initial of it. The requirement section 150 of the code is only the report was disclosed commission of cognizable and that sufficient set to investigate. Then para 84, the insertion subsection 3 of section 1 by way of an amendment reveals that the intention of legislature to ensure that no information of commission of cognizable must be ignored or not acted upon so and so, your lordship. Then I come to para 93, your lordship. The object of the sought to be achieved by registering an earliest information as FIR and iterate twofold. One, that the criminal process is set into motion and is well documented from the very start. And the second, that the earliest information received the entire commission of cognizable recorded and embedded. So then, your lordship, I take to 95. The police is required to maintain the several records, including case diary provided in section 150 as provided in section 44 of the Police Act, which held documentation, every info collected, spot visited, and all actions of police officers, so that the activities can be documented. Moreover, every info received relating to commission of non-criminal officer also has to register the section 150. Then para 96, 96, 97, para 96 says the underpinning compulsory registration of is not only to ensure transparency in criminal justice deliberation, but also to ensure judicial oversight. Section 157(1) deployed the word forthwith. Thus, any information received under section 154 or otherwise has to be duly informed in the form of a report of a magistrate. Thus, the commission of a cognizable is not only brought to the knowledge of investigators, but also submitted. Then para 97, your lordship. The court contains two kinds of FIR. The duly signed FIR under section 154 is the information or to the officer concerned at a police station. The second is FIR which could be registered by police station itself on information received or other than by informant, and even information has to be duly recorded in a copy of the magistrate for center basis. The registration of either on the basis of information furnished in the information under section 154, section 4 is obligate. The obligation section in advance. 97(1) says it's first step to access to justice. These are the guidelines they have given, your lordship. Then, okay. If your lordship will see, para 119, para 119, your lordship, page 60. Therefore, in view of various counter claims regarding registration or non-registration, which is what is necessary is only the information given to the police must disclose that commission of a complete cognizable offense. In such a situation, registration of FIR is mandatory. However, if no cognizable offense is made out on the information, then the FIR need not be registered immediately, and perhaps the police can conduct a sort of preliminary verification or inquiry for limited purpose of ascertaining as to whether cognizance has been committed. But if the information given clearly mentions the commission of a cognizable, there is no other option but to register an FIR forth. Other conditions are not relevant at this stage of registration, such as whether information is falsely given, whether information is genuine, whether information is credible. These are the issues that have been verified during the investigation of that. At the stage of registration, what is to be seen is merely whether the information given explains the commission of the cognizable. If the investigation given found is false, then all option proceed with a complaint filing a false FIR. Then para 20, your lordship, that gives a sub. In view of the aforesaid discussion, we held that one, the registration of a FIR is mandatory under section 154 of the code, and if information disclosed a commission of a cognizable and no preliminary inquiry is permission in such a situation. Two, if the information received does not disclose an cognizable but indicates the necessity for a preliminary may be conducted only to ascertain whether cognizable is disclosed or not. Then, if the inquiry discloses a commission in the FIR must be raised. In case where preliminary ends in closing the complaint, copy of the entry such closure must be supplied the first in forthwith and not later than 1 week. It must disclose the reason briefing for closing the FIR. Then 122.4, the police officer cannot avoid the duty of registering if cognizance is disclosed. Action must be taken against the erring police who do not if the information is disclosed. So this is very important. 124. The scope of is not to verify the veracity. So and so. You will see here. The issue is it is not denied, they have not said it's not a cognitive offense. The moment it's a cognitive offense, section 1 is mandate, it has to complaint has to register the FIR, Your Lordship. Here, that if you read, Your Lordship, read the complaint, clearly shows the cognitive offense. Drugs were seized. If seizing of the is not a cognitive, then my case is also not there. If that complaint cannot be registered in FIR, then the whole proceeding cannot proceed against me. How the drugs has come to that? You are not allowing the drugs to this thing. So in that case, under this the Supreme 5 case, a constitution-based judgment where registration of FIR is a compulsory, Your Lordship. That is the first. Then second thing is transferring the matter to CBI, because here, Your Lordship, it's a drug is an interstate trade, Your Lordship. It's coming from Myanmar side to this side, Your Lordship. Now, Your Lordship, I give Your Lordship the Delhi Special Police Establishment that. It's section 6, Your Lordship.
No, here your prayer is first to register. the FIR.
Then second is
Then to direct.
transfer to CBI for investigation under the control of this honorable court, Your Lordship.
Okay, why the second?
Second is because here you what has happened, Your Lordship. If Your Lordship say here the police officer, all higher police officers are involved. So you cannot get justice from they will suppress the whole thing. The way they have suppressed, nothing will happen. So CBI, because it will be interstate, Your Lordship. The drugs are coming in. It was on it. The drug, they are carrying the drugs in a car. So they have intercepted the whole. If Your Lordship have to, the source has to be picked up, not in the middle, Your Lordship. The source it will go to Manipur. Then all these things it will come. The whole chain has to be dropped. So it is a CBI who can do it, not the state police also. Now further, the state police should be biased. They vindicate because I, as an IGP, because I was stumbling block for them. They put me behind this thing on oral allegation. Nothing. They note nothing on record. Nothing on record. This thing. And how this? If they say that I allowed this drug peddler to flee, then how this drug peddler has come to the prosecution test to them? I'm sure Your Lordship will see the I enacted document also. If Your Lordship takes to page 83, Your Lordship. This is the disciplinary proceeding, Your Lordship. My Lord has got it. Page 83, annexure Roman 4 is there. This is the memorandum of charges I have there. If Your Lordship is 7 and 8, they are a drug peddlers, Your Lordship. They have been made prosecution which is by a respondent, Your Lordship, against me. So if I allow them to, and they are not traceless, how can these people be witnesses here for them in a disciplinary proceeding? So that means they are hand in glove with the drug peddlers.
Page 83, who?
Yes.
Rahul Kharel.
Yeah, Rahul Kharel and Deepak Lamba. It is there in the memorandum that who have annexed the other document. It is there, Your Lordship. Your Lordship, this Narola Sophie is the OC. Then Inspector, this 2 and 4 are the co-accused, Your Lordship. In the other FIR, Your Lordship. They have made it investigate, they have made it co-accused, Your Lordship. And they have acquitted them on the basis of their statement only. Then if Your Lordship, I just take Your Lordship to P9 also, that's my suspension order charges against me, Your Lordship will see. It is page 78, Your Lordship will see. This is where the disciplinary contempt, Your Lordship said, there was no, I was suspended, there was no generalized offense of seizure of GD so and so. No criminal case was registered. Then the 2 persons from whom the contraband was seized were released and the vehicle was released in Rebound. The seized contraband was kept in the personal custody of the returning IPS and not in a Malkhana. That's the allegation against me. That the seized drug has been kept in my Malkhana. Earlier it was there. Then the allegation is that then Your Lordship will see this. So it is only personal custody. The position is not there. So NDPS, all this act goes away against me. Now I am coming to the other part, Your Lordship. So it is drug is an interstate trade, Your Lordship. Drug traffic, you have to store the, it's come from Myanmar, Manipur, then Nagaland to Assam, that side. So it travels through, Your Lordship. So they were carrying the drugs in a car. So it is not originated from Nagaland. It is originated from outside the Nagaland state, Your Lordship. And the whole catching the carrier is not the issue, Your Lordship. Catching the main culprit. So main culprit CBI, because Nagaland police cannot investigate their itself. So at police,
By that logic,
no, but police are involved. Police officers are involved. Police officers, high police are involved, Your Lordship. They are shielding this accused. That's the CBI inquiry. Let the I don't want let the CBI inquiry against me also. I'm not shy on that. Let the
no. Why are you saying that high police officials are involved?
yes, I saw that because there's one document which I'll show Your Lordship where the Malkhana key was taken by the ADGP, Your Lordship. From 25th is there on record. 25th of March 2018, he has taken the key, and the drugs remain with how can the additional Director General Police take the key of the Malkhana? It should be the SP.
So where?
It's not that it is in this document I have put it, Your Lordship. It is in the other document that criminal petition, Your Lordship, that he has given instruction by Message that I have extracted, Your Lordship.
No, I am on the question
Yes, sir.
that one of the reason for
Yes.
handing over the investigation to CBI is that high police officials
Yes,
are
involved.
also involved.
Yes, sir.
To substantiate your
Yes.
submission,
Yes, sir.
one submission is that the key of the Malkhana was taken over
And
by.
the OC of the police station, who was made an accused, had been acquitted by Section 164 statement. How can she be acquitted? And I have been charged sheeted only on Section 164 statement of this accused. And it is exculpatory, and if you're lucky, I'll show it from that. It cannot be a recurrent confusion statement because Section 164(2) was not complied in any of the concessional statement. So on basis of the oral thing they put in a 161, then 161 is confirmed in 164. Now that is not a procedure, Your Lordship. There's no independent evidence which implicated me in any form, Your Lordship. That's a CBI inquiry I'm asking. Let the CBI inquiry, if I'm guilty, I will face the trial. I'm not shy of that. Let a fair trial be done. Investigate a fair investigation, fair trial be done. I'm not shy of this thing. Let them make me also one of the accused. I don't mind for that. I'll prove my case. There's nothing against me. Only an oral statement. There's orally I'm telephoning him not to do and on that day I was not there also. They said I handled because one day they said 6/7, 6/8 on the basis of call data record. The 6/8/2018 they handed over. I'll point out from that. If you take the charge sheet from the back, charge sheet for the first time is included that a GD entry was made on 6 and 17. That I have the drugs were given to me. Kept to be. I have asked for the drug on 6. That is the charge sheet only. That is not in the 164 statement, not in the earlier pressure. And the dates have come later on. Because what happened after this incident, I told them that there was the ADGP has asked for a report from this people. All these people have given a report. No one given that it is been a GD entry is there, or no dates have been given. Even in the suspension, no date is there. I've shown you. Even in the memorandum of charges in 2018, no charges. But at the stage of 161 statement, when 2019 was there, the dates came, the 6th and 7th. And call data record, they have put the call data record 6. They say handed over to me in my office in Kohima. On 6th, the call data record shows I was in Divapur, I was not in Kohima at all. So that 17 also same thing happened. So all these dates are all bungling. Later on, they put the dates. When I'll show it from because other matter, I can show it from the record that these are things happening here. So the moment you attribute, how can you get justice from them? They are planting at the last. It is reversing that. They are at 2009, 2021. They become more. They were aware of the 218, which they were not aware in 2018 yet. The fact they were aware in 2022 on their own, which are not there on 2018-19 year old. Can it be that? It should be other way around. Because 2018, the report doesn't say anything about this. I'll take your research report. They made, the police officer made, but there nothing on that date. Because the basic case against me is, I did on 6/7/2008, because there in the charge sheet, non-registering affair, these are not gone into, nothing is there. They have not done anything on that. They are simply on the 164 and 161 statement, they have implicated me. So question is, now, if your lordship will see, the drugs, because they filed their first charge sheet, they found it, they take it from the court custody. 20, they're in record here. 2011-2021, they took a sanction on 39-2021, your lordship. Then they filed a charge sheet, first charge sheet on 22-11-2010. Then they take it on 15-12 from the court conference. Then they 4/3/2022, they again went for 2 sanctions. And
No, these are in regard to the charge sheet.
yeah,
against
I'm
you.
just, because why your lordship.
In this case.
No,
the-
that's why I'm telling you why the prejudice, I'm saying why the police officer involved. That's why I'm pointing out this to show how this I'm handling it. Pointed why they have taken the first charge sheet against me. They have substituted by second charge sheet. That's not probably section 173. So all this, you have to see the totality of circumstances, how this cannot be investigated by the state police, your lordship. Because these are, I cited these instances to show that as to why this cannot be done, your lordship. Then they kept the drugs to their custody also. That also cannot be permissible, your lordship. The law rules, because question is, if your lordship will say, even I suppose I give order.
Mr. Chaudhary.
Yes, your lordship.
Slow.
Yeah, I'm sorry. I'm sorry. I'm sorry.
I have to understand. Your grievance is that the superintendent of police, who was the officer in charge of narcotics cell
Yes.
police station, though lodged a complaint on 3/8/2018.
No, he has not lost. It is lost by commander. Commander Narcos, to her.
Commander, yes.
To the OC.
Okay. Of the Naka checking
Yeah.
point,
Kuzba police.
narcotic cell checking point,
Yes, sir. Yes, sir.
who is the commander, he
Yes.
lodged a complaint.
Yes, written complaint.
However,
That was
no
not registered.
case was registered.
Not
This
registered.
is your grievance. Therefore, you showed Lalita Kumari that
Ah,
when it discloses an offense,
ah,
case ought to have been registered.
registered, your lordship.
So even if we agree
Yes, sir.
to it that a case should have been
Yes, sir.
registered, why it should go to CBI? Why it should not be, why it cannot be investigated by the state police? That is one question.
Yes, sir.
In answer to that question, you said that first answer is that interstate drug peddling
Yes,
is
sir.
involved.
Yes, sir.
But by that logic, all narcotic case should have to be handed over to CBI. That may not be a very strong logic. Second is that high police officials are involved against you.
Yes, sir. No, again, involved with
In
the
this case.
trade drugs is also, that's my allegation. That-
Okay.
Because the way.
Who can influence the
Yes,
investigation
investigate, that's the thing.
if it is done by the
State police.
state police?
It should
That
be
is-
impartial and independent.
Okay, that is one ground. Anything else?
So these are the two basic grounds, your lordship. Then your your lordship, even that.
And then subsequently, the charge sheet has been.
Yes.
No, a separate FIR was
File
lodged.
and charge sheet, these things are not
That is
covered.
not the subject matter
No,
of this case.
No.
That is of the criminal
Criminal,
petition
criminal, which is against me.
on 1/9/2018.
Yes, this is related to 1/9/2000.
Wherein the allegation was
Yes.
made that
Yes, sir.
you unauthorizedly kept the seized drugs
That's at
with
my
you,
custody. Yes, that is the allegation.
and which was handed over to you as per your oral instruction,
Yes, sir.
because you were a high police ranking
Ah.
official at that point of time.
That is the allegation, but the documents will show the other thing.
Okay, what else is there in this WPC?
Your lordship, the question is, when such prejudice is there, the Supreme Court judgment, that state of West Bengal judgment is there, that it has to be, it is a CBI.
When CBI should,
Yes, your lordship, that judgment I have given you, lordship. That is 2010. Three SCC 571. That's also constitution five judgments, Your Lordship.
Yes, you see 571.
Yes, sir. That's a five judge bench, Your Lordship.
What it says?
Just this, they said here actually basically the concept of state is that court can under two tests can grant send it to the CBI, Your Lordship.
Court can direct
Yes, sir.
CBI
Yes, sir.
investigation.
That para. In fact, there is one judgment of this honorable court also, which I happen to argue that matter, Your Lordship. Para 20, if Your Lordship, para 20. It is the manifest that in essence, the objection of the appellant to CBI's role in police investigation in a state, without its consent, proceeds on the doctrine of distribution of legislature as between the union and the state legislature, particularly refers to 3 lists of 7 schedules, the constitution and distribution of powers between the said 3 organs. In order to appreciate the controversy, a brief reference of some of the provisions of the constitution will be necessary. The Constitution of India is divided into several parts, each part dealing with detailed different aspects of social, economic, political, administrative. For the present case, we are mainly concerned with part 3 of the Constitution, which enumerates the fundamental rights guaranteed by the state primarily to citizens. In some cases, every resident of India, part so and so is pertinent to. Then, Your Lordship, I take to para 34. Para 34. This talk of section 5, the Special Police Act, Your Lordship. I gave a copy of that Police Act I have given, Your Lordship. Listen.
Yes, yes, it is there.
So that it says section 5, the powers of central government to extend the powers and duties of the special force to any area in the state, not being the union territory of the investigation offense, clause specified in a notification under section 3 and outside section of duties, a member of the established will discharge the function of police officer in that area and shall, while so discharging the function, be deemed to be a member of the police force in the area vested with the powers function in this. Then section 6 is called that concept of state government. Here court has rejected it, Your Lordship. Para 36. Having noticed the scope of section 5 and 6 of the special police, the question for consideration is whether restriction of the powers of central would apply immediately to the constitutional courts. As stated above, the main thrust of the argument is that the courts adopted by High Court directly CBI to undertake investigation in a state without the consent is incompatible with the federal structure and also the doctrine of separation of between the 3 organs of the state embodied in a consent, even when the High Court on the material before it convinced that the state police is dragging its feet under further. Then, Your Lordship, I take to para 51, Your Lordship. Para 51, Your Lordship. Para 51 says, the Constitution of India expressly confers power of judicial review on the court and the High Court under Article 2 to 36 respectively. The article as a very soul of the Constitution, the very heart of it, the most important article. By now, it is well settled that the power of the judicial review vested in the Supreme Court and the High Court under Article of the Constitution is an integral part of the essential constituting a part of basic structure. Therefore, ordinarily the power of the High Court and this court is to contest constitutional validity of the can never be ousted. Even the test of constitutional legislation can never be ousted, even every. Moreover, Article 13 of the Constitution not only declares the pre-constitutional law as void to the extent to which they are inconsistent with the fundamental rights, it also prohibits the state from making a law which either takes away totally or abrogates parts of fundamental. Therefore, judicial review of laws embedded in the Constitution by virtue of related Article 7. Then I take Your Lordship to para 53, Your Lordship. It is pertinent to note that Article 32 of the Constitution is also contained in part 3 of the Constitution, which enables the fundamental rights and not alongside the other articles of the Constitution, which define the general jurisdiction of the Supreme Court. This being the fundamental rights itself, it's the duty of the court to ensure that no fundamental controversy or abridged by the statutory provision. Moreover, it is also plain from the expression nature employed in the clause 2 of Article 32 that the power conferred by the state clause is in the widest term and not confined to issue. High prerogative is specified in the clause, but includes within it ambit of power to issue any direction or writ which may be approved and enforced fundamental right. Therefore, even when the condition for issue of this writ are not fulfilled, this court would not be constrained to fold its hand in despite plead inability to plead citizens so and so. Then, Your Lordship, I take Your Lordship to para 68. The conclusion for Your Lordship. Thus, having examined the rival country in the country of Constitution, we conclude as follows. One, the fundamental right under part 3 of the Constitution are inherent, cannot be anticipated by any constitutional statutory authority. Any law abrogated or abridged such right would be violative of basic structural doctrine. The actual effective impact of law rights regarding part 3 has to be taken into account in determining whether or not to destroy the basic structure. Article 21 of Constitution is broad perspective, seeks to protect the person of the life in a personal liberty except according to the procedure established by law. The said article in its broad application not only takes it for enforcement of a right of an accused, but also a right of the victim. And the state has a duty to enforce the human. The state has a duty to enforce human rights of the city, providing fair and impartial investigation. This is very important. Fair against the person accused of commission of a crime, which may include his own offenses. In certain cases, even a witness to the crime may seek for shall be granted protection by the state. In view of the constitutional scheme, the jurisdiction conferred Article 32 or the High Court under 30. The power of judicial review being an integral part of basic structure, because no act or parliament can exclude or curtail the power of the constitutional court with regard to enforcement of fundamental rights. As a matter of fact, such power is essential to give practical consent to the objective of the constitution embodied part 3 or other parts of it. Moreover, in a federal constitution, the distribution of legislative power between the parliament and state legislature involves limitation on the legislative power, and therefore this requires an authority other than parliament to ascertain whether such limitations are transgressed. Judicial review acts as a final arbiter, or not only to give the effect to the
Now
distribution.
come to clause 7.
Yes, sir. Clause 7, yes, sir. When a special act itself provides the subject matter consent of CBI, the state can take up interest in relation to crime which are other within the judicial state. The court can also accept constitutional or judicial review directly to take up the interest within the judicial of the state. It's very clear. The power of the High Court under the Constitution cannot be taken away, curtailed by Section 6 of the Police Act. In respect of there being a statutory provision as a restriction of the power of the court, the restriction imposed a section on the power of union cannot be read to restriction of power of consent. Therefore, in excess of the power judicial review by the High Court, I don't know would amount of infringement of doctrine of separation. Then Section C, para C. In the final analysis, our answer to the question is referred to the direction by the High Court in excess jurisdiction under 220 of the consent to CBI to investigate cognizable or alleged to have been committed within the territory of a state without the consent of the state will neither infringe of a federal structure nor violate doctrine of separation and shall very valid. Bring the protection of civil liberties of this court, the High Court have not only power to and jurisdiction but also obligation to protect the fundamental rights guaranteed in Part 3 of the Constitution. Then 70. Before parting with the case, we deem it necessary to emphasize that despite the wide powers conferred Article 2, while passing on the court must bear in mind the self-imposed limitation, exercise consequence. The very principle of power in the article said requires great caution to exercise insofar as directions conduct in case of concern. Although no inflexible guideline can be laid down to decide whether or not such power could be exercised, the time and again have reiterated that such order is not to pass as a routine or merely by a party level allegation. The external power must be exercised sparingly and cautiously, where it becomes necessary to provide credibility in self-confidence when the incident happened national internet where so and so doing so. So you'll actually see here, the issue is
Power is there.
power is there, that is there, and there is a judgment of this honorable court also. I just this is reported in 2016 3 GLT 798. Your worship. Just this is there. Your I can take it. Well, this is the judgment of this High Court. Your worship.
It's
I argue
that
this matter.
Power is there.
Yes, the High Court has transferred to CBI.
Okay.
This Justice Ujjwal Bhai is Den was here. He's here also. The para 1921. The paras are there. They have discussed this judgment. I just give you the para number. Para 1921, then 24 here, except 24, 11, 12, 13, 14, 15, then 26, 27. So here also they have transferred it to CBI also. And in fact, I just came across another judgment I located by I saw in the newspaper, Your Worship. One justice delivered by Justice Honorable Justice Sumant Sen in respect of transferring the CBI case to CBI because regarding an investigation, Your Worship. I just don't remember. There's a judgment of this honorable court. I think last date was given. I think in the month.
Okay.
Justice Sumant, I couldn't lay hand on the judgment, Your Worship. That is regarding to some murder case, some case in NC Hills, Your Worship.
Okay. So your submission in writ petition criminal is over.
Yes, now that's transferring to CBI. Your Worship. They're transferring because here, if you watch the intermingling of police officer drug peddling is clearly found out. So there I cannot get a fair investigation here. So CBI is necessary here. Because the judgment has said unless there is impartial and this inquiry is investigation is assured, you cannot do it. You know. The state police cannot do it because they are involved. And all high police, he's a rank of IGP, all these people, because people like to see the whole thing, the whole thing, the way it is going on. So that's why I feel that let it be investigated by CBI under the control of this honorable court. Because let the truth come out. And I'm not, I want, if they want me to prosecute me, I don't mind in that FIR also. I don't mind.
Okay.
Let there be this thing.
Okay. Ms. Sukre,
Yes, Lordship.
you will give reply case-wise or at a time?
At that time, Your Lordship, let my learned friend completed his submission, then only
Then
after.
let us
Yes.
come to the criminal petition.
Yes, Your Lordship. Your Lordship, this criminal case 27.
In this case, your basic submissions were that FIR ought to have been registered in
Ah.
the earlier case. It was not
Which has not been
registered.
cognizant offense made out, not registered.
And you apprehend.
And you
that-
can take under the judgment, police, you can proceed against the police officer also. That judgment is taken. I pointed out the portion also.
Now come to criminal petition.
27 of 2022. In this petition, the state government has not filed reply to the Your Lordship. You point out that first, Your Lordship.
No, state government may not file.
Yeah, I
reply.
pointed out because there are some things are there which are they have not denied, Your Lordship. Then, Your Lordship, I may take Your Lordship because
Yes, Mr. Chaudhary.
Yes, Your Lordship. Here, if Your Lordship will see, I'm just going
Here,
to
what relief you are seeking?
questioning of the charge sheet.
Quashing of the
Yes,
charge sheet.
questioning against me, Your Lordship, questioning the charge sheet.
Charge sheet was laid against only you.
Only me, only me. Because the case records are also there, Your Lordship. Documents are also there.
Yes.
Your Lordship, take the, FIR is also here, Your Lordship. Yes. Let me take Your Lordship, because I just want to point out one thing of that charge sheet, then I'll come back to here, Your Lordship. But that will, charge sheet, if Your Lordship will see. This is very important.
At page,
I can give me a minute, Your Lordship. Just one, I think. If Your Lordship, page 163, one paragraph. (16.19A), 19A. On, where is it, Your Lordship? 163, page.
16 point.
19A. On 6/8/2018, Richard Ito directed UBI carrier to produce 1 packet of suspected brown sugar at his office chamber to check the sample. The packet was removed from Walkhana and handed over to him at his office chamber by UBI so-and-so and UBI Licheng Lotha. Licheng Lotha is the person who lodged that criminal complaint. The first one, which is the packet was not returned. It was found reflected in both General Diary and the Malkhana enclosed D19. Your Lordship, this is important because here, for the first time, they said General Diary entry was made, and I'll take you back now to the initial portion, Your Lordship. Now, Your Lordship, what has happened? The moment.
No, that the
Yes, sir.
fact that you have not returned back the contraband was mentioned in general diary entry.
No, it is not there. It's not there. It's not returned. They have taken, the moment I give it, I have given it immediately.
No. In the charge sheet, in charge sheet
Yes, Your Lordship.
at page 163,
Yes. Yes,
the
sir.
entry made in the charge sheet on the basis of a general diary entry.
But this general diary was not there. That's what I point out.
Okay.
General, if your lordship, this was charge sheet was filed 2022, your lordship, 16. Now I'm coming to 2018, your lordship. After this was detected, your lordship, then the ADGP called for some report from these same officers. That I'll take your lordship to here. That is, your lordship will start from page. If you, then I'll take your lordship to the Caesar memo, your lordship. Caesar memo, if you page 97, it is there. 98. This is the first. This is the sorry. This is 38. So your lordship, this before that, then what happened, your lordship? I informed the because what happened actually, basically my case is that the Malkhana was not safe. They have their night security. They have not proper night security. So at the request of the OC, I took it to my residence because I have 24-hour security in the residence, your lordship. And this fact was informed to the DGP also. Then DGP asked for a report from this, asked ADG to make an inquiry, your lordship. And in that inquiry, if your lordship will see, the inquiry reports are there, your lordship will see. This is 28/8/2018, page 99, it starts, your lordship. Then your lordship, I'll take you to page 100, your lordship. This is the gentleman who wrote the written complaint, 3/8/2018. He is PW4, your lordship. Yeah. In this connection, the matter was, my lord has got page 100. I see narcotics through mobile phone, and he directed me to report to SPTL. Accordingly, I reported through mobile phone, and she again directed to report a matter to IGP. As per that, I called up the IG to report a matter, and he directed to bring the arrested person. So he told me not to disclose the matter. So yeah, if your lordship will see, 28/8/2018. This gentleman, he didn't mention anything about taking of drugs by me on 6/8 or 17/8, your lordship. And about the GD entries also. Nothing is mentioned. Then I come to the next report that he is the co-accused, your lordship. He is the IC in narcotics cell, your lordship. Here also, if your lordship will see, what he says, page 101, your lordship, as directed over phone by IGP, Commander Narcotics Cell, page 101.
Yes.
As directed of the Commander Narcotics Cell has self took and seized the items and showed to the Inspector General in his office. This was not stated by the Commander. PW4 I showed him. He has made a statement on himself. He directed us to keep the seized bottom in item narcotics. I asked him to register, but he said he will issue necessary to SP so and told us to keep the control item in the Malkhana. SSP called me and said to his office chamber, and she IGP through phone and asked him to register, but he directed SSP over phone to release the accused and along with the seized vertical so on telephone. The CDR doesn't support that also. Then here after 3 to 4 days back, IGP asked for 1 packet of seized contraband items to see the sample. So along with UVL went to the police station Malkhana, took out 1 packet of the handover to aim to office chamber. Here he said after few days, no date is there. Date came only at a charge sheet stage, like a subsequent. Then he doesn't know date has been specified here, and nothing about GD entry made on 6th and 17th. This is a report given on 28/8/2018. Then comes the OC. He made a statement, a report on 25/8/2018. I instructed the commander to inform the ICP, if your lordship see page 104. I instructed the commander IGP accordingly. There was a direction given. Henceforth, whenever there is any direction, he should be informed on spot and WhatsApp accordingly. On receiving, I learned that the commander was directed to produce the illegal custody to the office chamber IG. So that was the only thing, your lordship. Then here also, nothing about handing over the drugs on 6th and 17th to me. The OC doesn't say that. Then 106 he states again, 106, the IGP said through intercom, not telephone, directed not to register a case and release the 2 accused on PR1. He further told me to keep the concerned office and Almira, which are fair. So here, your lordship, in the IPS, this Central Service Regulation is there. They said when you give an oral instruction, it has to be in writing somewhere. Without where a oral giving oral say not instruction at all. I just give you that this thing, your lordship, that is there. Yeah. That is. You give that. CCS will save that. I'll give that. I'll give that to there. So that is, then I go to the next text on your, the Director General of Police, this is ADGP. He went a step further, your lord. ADGP's report to the DGP after getting this 3 report, page 180 for the say. After effecting the CJ, report was committed to all immediate countries, including Inspector General Police Nagaland. As per the statement of Commander so and so, IC so and so, they were instructed to release the 2 vehicles and a vehicle and also release suspect to the IGP in person. Despite the narcotic officer to register the case, so I said the 2 arrested were released on PR1. There, IGP asked the entire country to deliver. See, here you will see the contradiction is there. He, according to the report is something else. The ADGP, this report is given submit to ADGP. ADGP is giving support report to the DGP. He has said that I took it on that day itself. Therefore, the IGP took the entire country to deliver at his office chamber. He doesn't talk about 6 and 7, your lordship. Then, if your lordship, next para. The apart from there is no general effect seizure of GDN to a and close also no criminal case. 2 persons on whom contraband is released. So and so affects contraband brown sugar kept in a personal custody and not in the Malkhana narcotics and aviation. The undersigned has inspected Malkhana 24 found no trace of so and so. So here also that 6 and 17 and GDN nothing has been mentioned, your lordship. Because 6, 7 either they have interpreted later on after the filing of before filing of charge they put these dates. Then if your lordship will see even
One of the allegation.
Yes,
that
sir.
no case was registered.
yes, sir.
That is an allegation against you also.
But I am not supposed to raise an allegation. They are oral statement. There's nothing on record. They're setting orally, and they have put this statement on 160 on 164. And it's so far non-registered FIR, charge sheet has not done it here. They have not done charge sheet at all on that. Charge sheet has nothing said on the non-registered FIR, nothing on that. That's what referred in the winter. Non-registered FIR, releasing of the vehicle, nothing is the charge sheet contains nothing. Then if your lordship will see the seizure on 1/9/2018, that is start from page 111, your lordship. If your lordship will see this page, page 112. Who sees the material? Under the signature, it was there with me, and the moment I handed over to him. It is not the case that something is missing. If your lordship, page 112, if your lordship see, bottom. It was signed by Narola's office. She is the OC. She is the person who sees, and she is a co-accused also. And witness number 1, he is also a co-accused, your lordship, who have been discharged by the investigation. Witness number 1, his name is Keikeri Angami. That's one this time. Here. So he's the IC in charge of the narcotic cell. So this, thus, if a lordship will say seizure memo is defective also, no independent witness, the accused have, they are accused and they are looking at seizure memo against me, your lordship. No independent, although the independent witness have not been examined. Then if a lordship will see the memorandum of even if your lordship will see, I showed you that suspension order, your lordship. That is, there's nothing about the 2 dates. Suspension order, I've annexed it at page 100p10, your lordship. If your lordship will see down below, this I have read it already, your lordship. Page 118p10. If your lordship will see this, there's nothing on the GD entries and everything on that there. That's kept in the personal custody, nothing of that I have taken over here. Then memorandum of charges in the disciplinary proceeding, your lordship. That also doesn't say anything about that. I just showed you the not there also. It is there here. If your lordship, that's memorandum of charges, if your lordship, 118 is your lordship. Yes.
What of it?
118 is your lordship. This is the suspension order. Now, which I read in the other material, that suspension. Yeah, if your lordship, that's clause, no generalized reference, these are the charges against me. Nothing about making of GD entries are there. That's what happened. Then your lordship, I take your lordship to memorandum of charges. That starts P11 starts, your lordship. Then I take your lordship directly to that page, your lordship. Page 125, your lordship, that same thing. The said Richard Imto after some few days, here dates are not mentioned, your lordship. This is on 18/12/2018. The said Richard Imto, my notice on page 125. The said Richard after some few days, no dates are mentioned, of the seizure of the illegal suspect drugs, directed the in charge narcotics authority to bring one packet of seized contraband drug to see the sample, the same which was handed over. In his office, and after some few days, the IC narcotics cell was directly produced the whole seized illegal drugs, and so in charge took the remaining 10 more and seized item and handed over to the in the office. Therefore, Richard stated that he took all the way to his residence and kept in his locker such kind of illegal processing is for personal gain. Your lordship will see here. Two things are there. Here, no dates are mentioned. 6/8/2018 and 17/8/2008. No, nothing about DT entries. So this also shows that. Then your lordship will see. Then I have to take a lot of the records of the case also, your lordship.
You are stopping now. On next date, you submit a gist of your submission. In the second case, not in the first.
No,
case.
no.
First case is okay.
First case, okay.
In the second case where you have prayed for quashing of the charge sheet,
Yes, sir.
why are you making such prayer?
Yes.
What are the grounds for?
That I'll do. I'll elaborately dealt with the petition. I'll tell you.
You give it this.
I'll do.
Written this.
I'll do.
When will be convenient?
Because 23rd, your lordship is having another matter. So again, that same problem will come. 23rd, I think you fix another matter at 3 p.m. I think.
About this.
Then make it 25th till 25th will be better. 25th. 23rd, because that is one where your lordship has fixed that the other matter at 3 o'clock. So again, that problem will come up. 24, I have no problem.
24 is okay. Not at 3 p.m. At 2.
I'll do it. No problem. I'll do it. That is all.
Miss Sokre?
Lordship, 24, there will be a division page, so I may have a difficulty. So, Lordship, on 23 or 25th will be
25th,
okay.
the problem is definitely that
25th.
25th, I'll do, no problem.
25th at 2.
If you wish.
Heard Mr. P. Chaudhary, Learned Counsel for the petitioner,
Assisted by D. Talukdar.
assisted by
G.
Mr.
Talukdar.
G. Talukdar. Also heard Ms. V. Sokre, Learned Public Prosecutor, Nagaland. The hearing remains inconclusive. Let this matter be listed again on 25th January at 2 p.m.
Yeah.
As a part of.
Deeply obliged. I'm highly obliged.
That's okay.